Beth Robinson, nominated to the Second Circuit, Jennifer Sung, nominated to the Ninth Circuit, Dr. Raul Gupta, nominated to head the Office of National Drug Control Policy, Elizabeth Prelogger, nominated to serve as Solicitor General of the United States. With today's slate, the Biden administration and Senate Democrats are advancing nominees well qualified who bring important professional and demographic diversity. I'd like to note several historic firsts among today's nominees. Upon confirmation, Justice Robinson will be the first openly LGBTQ woman on an appellate court. Ms. Sung will be the first Asian American woman to occupy one of Oregon's 9th Circuit seats, and Dr. Gupta will be the first medical doctor to head ONDCP. A number of our colleagues will introduce our two judicial nominees, and Dr. Gupta, I have the privilege of introducing the nominee to serve as our nation's next Solicitor General. Elizabeth Prelogger is without a doubt one of the most accomplished appellate litigators to have been nominated to serve in this position. She's argued 9 cases before the Supreme Court, submitted cert petitions, merit briefs, amicus briefs, and hundreds of additional cases. Outstanding choice, frequently referred to as deferred position, frequently referred to as the 10th Justice. Born in Boise, Idaho, Ms. Prelogger graduated summa cum laude from Emory University before earning her master's in literature from the University of St. Andrews in Scotland. She then went on to earn her J.D. magna cum laude from the Harvard Law School. After clerking for then Judge Merrick Garland and twice clerking on the Supreme Court, once for the late Justice Ginsburg and once for Justice Kagan, Ms. Prelogger began a career as an appellate attorney. Initially joining the appellate practice at Hogan Lovells, Ms. Prelogger has spent 5 years as a career attorney in the Department of Justice. As an assistant to the Solicitor General and an assistant special counsel in the Office of Special Counsel, Ms. Prelogger worked for both Democratic and Republican presidents and came to develop a profound appreciation for the traditions and practices of the Office of Solicitor General. After returning to private practice at Cooley LLP, Ms. Prelogger was chosen to serve as the Biden administration's acting Solicitor General, a role she held from January 2021 until her nomination last month. 2 brief observations about her career. First, having served under both Democratic and Republican administrations in both career and political roles, Ms. Prelogger not only has an unwavering commitment to provide unbiased legal advice, but understands the critical role that career attorneys play within the department. Second, having served in the Justice Department during the Trump administration, she demonstrated her ability to advance legal arguments irrespective of her own personal or political belief. Given her experience and her reputation as a principled, outstanding advocate, it's little surprise that Ms. Prelogger has broad bipartisan support. The committee has received letters from 12 former Senate-confirmed and acting Solicitor Generals from the George H.W. Bush, Clinton, George W. Bush, Obama, and Trump administration. They include Solicitors General Ted Olson, Paul Clement, and Noel Francisco, among others. These 12 former Solicitors General wrote, Elizabeth's prior experience in the office give her an appreciation for the norms, traditions, and responsibilities, and prepare her well in leading the office. They add, quote, we are confident that she has what it takes to serve as Solicitor General. The committee's also received letters of support from a bipartisan group of Supreme Court practitioners, many of whom served in the Republican administration. They write, and I quote in part, the Solicitor General role is challenging, demands intellectual honesty, consistent open-mindedness, and a willingness to listen. Throughout her career, Elizabeth Prelogger has demonstrated these qualities. She treasures legal rigor, respects all persons, is fully committed to serving the public interest. High praise from leading practitioners, but in particular a group that includes Republican former officials like Don Ayer, John Bash, John Elwood, and Peter Keisler. Without objection, I'll enter both of the letters into the record and look forward to hearing from all our nominees shortly after turning first to my friend and colleague, Ranking Member Chuck Grassley.
Thank you, Mr. Chairman. Before I give my remarks, I want to recognize the leaving of the committee staff of Mike Fregoso. He was chief counsel for nominations, and before that, he worked for Chairman Graham. Mike was an invaluable member of my team. He cares deeply about the rule of law. He understands the duties that we have here in the Senate, and he navigates the fine details of Senate procedure with ease. Mike left our committee during the August recess, but this isn't the end of Mike's time with the Senate. He's now going to be Mitch McConnell's office as chief counsel, and I'm sure that he'll continue to benefit from his work, or we're going to benefit from his work in that office. I also want to introduce my new chief counsel for nominations, Brendan Chestnut. Some of you may know him from previous service. He worked for some of our country's leading law firms. He clerked on the Ninth Circuit, and he previously served as nomination counsel for the Judiciary Committee. So we welcome Brendan back, and I'm glad to have you here. We have 4 nominees today, 2 Circuit Court, Solicitor General, and 1 Director of Office of National Drug Control Policy. Before speaking about the nominees, I want to address the protests by left-wing activists outside of Justice Kavanaugh's home last night. A partisan group announced that Justice Kavanaugh was going to hear from us directly, quote unquote, hear from us directly, because he has been, quote unquote, protected from any backlash for his votes on the Supreme Court. This protest looks like another blatant attempt to intimidate the judiciary and anyone who disagrees with the radical agenda pushed by partisan advocates. After all, a leader from this group recently pleaded no contest to criminal trespass and was ordered by a court to stay away from Senator Hawley's wife. Partisan shots aimed at the independence of our judiciary ought to be concerning to everybody. Dark money groups like Demand Justice run dishonest attacks to try to undermine the people's trust in the federal judiciary. These groups do it for partisan purposes. They want to bully judges into ruling in line with their liberal agenda, no matter what the law says. And if that doesn't work, they want to pack the court. I believe the American people will reject the extreme agenda of these left-wing groups. Now to today's agenda. Justice Robinson is nominated for the Second Circuit. She currently serves on the Vermont Supreme Court. While in private practice, Justice Robinson did a fair bit of civil rights work. And as I said before, so did Judge Michael Parks and Judge Stephen Menesha, who President Trump nominated to the same Second Circuit. Judge Park fought against racial discrimination in higher education, and Judge Menesha fought against religious discrimination in the Department of Education. I supported both of those nominees because I felt confident that their judicial philosophy meant that they would rule based on the law, not their personal views. This administration's nominees have generally refused to answer questions about their judicial philosophy, at least when asked at a hearing. It's hard to support a judicial nominee who won't tell us their approach to deciding cases. It also is hard to support a nominee for lifetime appointment if they haven't thought enough about the job to have a judicial philosophy. Justice Robinson has served as a state court judge for several years, so I hope we can have a productive discussion about her judicial philosophy. I will also note that Justice Robinson's support comes from Vermont and its legal community. Ms. Sung is the second nominee, and she is nominated for an Oregon seat on the Ninth Circuit. Judge Graber, who currently sits in that seat, is well respected. She has said that some of her favorite cases involve interpreting statutes because it's like a puzzle. She likes working out how different parts of the law fit together. Because of that, she takes an interest in many different areas of law. I see Ms. Sung this way, focusing intensely on labor law and working closely with labor leaders. That may be why Demand Justice and Chris Kang are excited about her nomination, and why Ms. Sung's strongest supporters seem to be in San Francisco and Washington, D.C. She has also made a number of partisan statements about judicial nominees. Given those comments and her narrow focus on the law, I'm not sure she's a good fit for the Ninth Circuit, which sees a broad array of cases. On the second panel, we have the administration's nominees to serve as Solicitor General, Ms. Perlagar. She has an exemplary resume. She clerked for 2 Supreme Court justices. She serves as acting Solicitor General for several months before her nomination. She may carry out this administration's priorities very well, but I'm concerned about recent choices made at the Department of Justice. I hope she will show a willingness to be a voice of reason there and push back on partisan decisions that I've seen recently in this administration. Finally, Dr. Gupta has been nominated to serve as Director of Office of National Drug Control Policy. He has served in public health roles in state and local governments and has an extensive experience dealing with opioid crisis. I hope today's hearing shows that he is a good fit for that role. Thank you.
Thanks, Senator Grassley. Let me respond very briefly to your comments about the demonstrations before a Supreme Court justice's home last evening. Politics ain't beanbag. We all know that you have to have a tough mental hide to be in this business, but it is absolutely unacceptable from my point of view to involve any major public figure's family or their home, or to involve yourself in criminal trespass in the name of political freedom of speech. I think most of my colleagues share this feeling. We're the ones with our names on the ballot. We're the ones who are elected. There are proper venues to express yourself, and I don't believe a person's home or their family should be fair game in this business. I concur with your thinking on that. And when it comes to criminal trespass, we got a belly full of that on January 6th. I don't care whether you're right or left. That is unacceptable as far as I'm concerned in expressing your political feelings. Well, we have a number of colleagues who are here to speak on behalf of the nominees before the committee this morning. And we'll start with Senator Leahy. How about that?
Well, thank you, Senator Durbin. Incidentally, both as a senator and as a former prosecutor, I totally agree with what you just said. You can state your opinion of any one of us at the ballot box. You can write letters and try to intimidate family. Anything like that is wrong. But on a happier note, I couldn't be more proud to introduce Vermont's very own Justice Beth Robinson at her confirmation hearing this morning to serve as a judge on the Second Circuit Court of Appeals. Senator Sanders and I both know that Vermont traditionally has one seat on that circuit, and so we try to have the absolute best, and we've done that here. I know their mother Cynthia, her sister Barbara, her wife Kim, all are here in the audience today. And I was talking to them earlier, we all share that same sense of great pride. And I can say with confidence that Vermonters, regardless of party or ideology, are delighted that President Biden nominated Beth Robinson to fill the Vermont seat on the Second Circuit. Last month, as I went around our state of Vermont, I had so many people, Republicans and Democrats, come up and say, this is a great choice. She's been hailed as a tireless champion for equal rights and equal justice in the mold of the late Justice Ruth Bader Ginsburg. It's no exaggeration to say that Beth helped Vermont and America more fully realize the meaning of equality under the law. Thousands upon thousands of LGBTQ individuals across the country are able to live their lives with dignity thanks in part to the pioneering advocacy of Beth Robinson. And her nomination is truly historic. But these are not the primary reasons that Beth Robinson is sitting before us today. Instead, it is Beth's track record as a Vermont Supreme Court justice, her fairness, impartiality, and loyalty to the rule of law that make her the best possible nominee for the Second Circuit position. All current Vermont Supreme Court justices appointed by both Republican and Democratic governors have signed a letter supporting Beth's nomination, praising her as an excellent jurist who is measured. And the Chief Justice of our court, appointed by a Republican, went out of his way to tell me that personally. 3 former Vermont Supreme Court justices, again appointed by both Republicans and Democrats, have written letters of support for her. Vermont's Republican Governor Phil Scott has penned a letter urging her confirmation, and he noted that she was unanimously confirmed in a bipartisan show of support by the Vermont Senate. Every Republican, every Democrat voted for her because she is widely respected for her character and integrity. Mr. Chairman, I ask that those letters be included in the record.
Without objection.
And then the list of support letters from leaders across the political spectrum go on. Testament to her unimpeachable, decade-long track record as a jurist dedicated to her craft, loyal to the law above all else, and it's these qualities, compassion for all parties appearing before her, collegiality with those who disagree with her, and a brilliant legal mind that make Beth Robinson the right person for the job. So I urge all senators to evaluate Justice Robinson's record. It's our solemn obligation as senators to provide advice and consent to the president's nominee. And I think the senators of both parties will see, as I have, that Justice Robinson possesses exactly the right qualities, skills, and experience to excel as a judge in the Second Circuit. I congratulate Justice Robinson. Delighted to see her family here, this historic nomination. And I look forward to seeing her expeditiously confirmed to the Second Circuit. Thank you, Mr. Chairman.
Thanks, Senator Leahy. Senator Sanders from Vermont.
Thank you, Chairman Durbin, Ranking Member Grassley, and Senator Leahy. Today, it is my privilege to introduce Vermont Supreme Court Justice Beth Robinson, who has been nominated to serve as a judge on the Second Circuit Court of Appeals. Justice Robinson is undeniably one of the most notable champions of equal rights and equal justice, and in particular, she is one of our nation's most important pioneers in advancing LGBTQ rights. In the landmark case of Baker versus Vermont, then Attorney General Robinson secured a ruling in favor of marriage equality in 2009. This was one of our country's first major advances in LGBTQ rights. It was a major step towards our laws acknowledging that people have the right to love whomever they want and to get married regardless of their sexual orientation. As a direct result of this victory, Vermont's legislature enacted the first civil union law in the country. Vermont has led the country on this issue, and that is due in no small part to Justice Robinson's dedication and hard work. Justice Robinson is extremely well qualified for this position on the federal court. She has served on Vermont's Supreme Court since 2011 and has built a reputation for her impartiality and fair application of the law. She treats people with respect and compassion, and she understands the duty of the court to provide equitable justice. I believe she will make Vermont proud and that she will be an excellent addition to the federal bench. Congratulations, Justice Robinson, on your nomination. Thank you for your continued service to our country and for your commitment to equality and justice. Thank you, Mr. Chairman.
Thanks, Senator Sanders. The committee and those in attendance all understand that you have a busy schedule and that if you have to depart anytime soon, it's understandable. We're honored to have Senator Ron Wyden of Oregon here next.
Thank you very much, Mr. Chairman, and I'm pleased to be able to introduce Jennifer Sung, my neighbor who lives around the corner from me in southeast Portland, who's President Biden's nominee to serve on the U.S. Court of Appeals for the Ninth Circuit. And I'll listen to our colleague, my friend, Senator Grassley, say that Ms. Sung's supporters were located in various parts of the country. Her strongest supporters, Senator Grassley, are 100% of Oregon's United States senators who live in her neighborhood in southeast Portland. Now, I got to know Ms. Sung through a variety of conversations. I'm going to keep this brief. And I was struck that the story of the Sung family is much like the story of the Wyden family. The Sungs fled violence and political persecution in China in the 1940s. My dad fled the Nazis in the 1930s, got into the United States Army, and was involved in dropping propaganda pamphlets on the Nazis. Both of our families were ecstatic to come to the freest and most open country on earth, where we were able to find safety and opportunity. In both families, the Sungs and the Wydens, we were taught to give back to America. Ms. Sung did that, helping low-income patients who needed assistance with their health care. The Wydens, as you know, pitched in with senior citizens. I will also say, when you look fast forward at her qualifications, serving as the second term as a member of Oregon's Employment Relations Board, which adjudicates disputes over labor practices and employment law in my home state, she has brought stellar impartiality to the effort. She decided more than 200 cases, and her impartiality and commitment to justice, and I say this particularly because I heard comments about my good friend Judge Graber, she follows in that Graber mold of academic excellence and impartiality. Finally, Ms. Sung's qualifications and her experience really stand, as I stated, on their own. Her nomination and her eventual confirmation is also going to help make the courts look a little more like America, a little more representative of what our great nation is all about. I offer a full and unqualified endorsement of my neighbor, Ms. Jennifer Sung, to be President Biden's nominee to serve on the U.S. Court of Appeals for the Ninth Circuit.
Thanks, Senator Wyden. Now from the same neighborhood, Senator Merkley.
Thank you so much, Chairman Durbin and Ranking Member Grassley and men and women of the Judiciary Committee for the opportunity to echo the sentiments of Senior Senator from Oregon, who has stated it so well, that Ms. Jennifer Sung is an exceptional Oregonian, nominated to fill a vacancy on the Ninth Circuit Court of Appeals. As we have seen time and time again, it's absolutely critical that we have nominees to the federal bench with the experience and expertise necessary to serve the American people and the rule of law. And it's essential that they will protect our nation's values of freedom and equality for all and will ensure equal justice for all, stressing the word equal, working with legislators to make sure there are as many protections for the rights of ordinary citizens as for the powerful and the privileged. That's so often not the case, and we need champions to make it be the case. Ms. Sung has shown throughout her remarkable career that it's precisely those attributes that she will bring to the Ninth Circuit. From her days as a union organizer working to help ensure a voice for working Americans, to her time as a litigator specializing in labor, employment, and constitutional law, right up to her time as a member of our state's Employment Relations Board, where she helped to decide over 200 cases. Ms. Sung has been a steadfast champion for American workers and a committed servant to the public interest. When confirmed, she will bring with her a breadth and depth of knowledge critically needed on the federal bench. She will add much needed diversity, not only in heritage and culture, but in real-world experiences to a bench that does not come close enough today to representing the broad range of experiences, cultures, and heritages that make up our richly diverse nation. Most critically, Ms. Sung will bring with her a passionate and dedicated commitment to ensuring equal justice for all Americans, so I am proud to join Senator Wyden in giving her my full support. Thank you for the time considering her nomination. I hope that after this hearing today, you will be as impressed as Senator Wyden and I have been, and will recommend Jennifer Sung's confirmation to the Ninth Circuit and encourage expeditious consideration by the full Senate. Thank you.
Thanks, Senator Merkley. Next, we have West Virginia senators here. The entire delegation has arrived, and they're here to introduce Dr. Gupta. Senator Manchin, we'll start with you.
Thank you, Senator Durbin and Senator Grassley, and to all my colleagues and friends that sit on this prestigious committee. We're going to stay in the same neighborhood, so we're in good shape here. It's an honor introducing my fellow West Virginian to the Judiciary Committee today, Dr. Rahul Gupta, nominee for the Director of the Office of National Drug Control Policy. But first, you need to know about this person. Before I start with his incredible career, I want to note the wonderful people who support Dr. Gupta that are here today. His wife, Dr. Seema Gupta, and Dr. Seema Gupta, who currently serves as a physician at the VA. Dr. Seema. And then he has twin boys, Arca and Drew, and I've known these boys since they were babies and watched them grow. Now, here's the accomplishment. They both completed undergraduate degrees at Yale. They both are at Harvard now, one in law and one in medicine. Now, I think that says everything you need to know about Dr. Gupta. First of all, to have such an accomplished family and as a father and a husband. Dr. Gupta currently serves as the Chief Medical and Health Officer and Senior Vice President at the March of Dimes and Interim Chief Science Office overseeing the research and global health portfolio, a clinical professor in the Department of Medicine at Georgetown University School of Medicine. He is also an adjunct professor in the Department of Health Policy, Management Leadership in the School of Public Health at West Virginia University, and visiting faculty at Harvard T.H. Chan School of Public Health. I'm proud that yet another West Virginian has been nominated to serve the American people, and I have no doubt that Dr. Gupta will be a dedicated director of the ONDCP. As a longtime resident of our home state of West Virginia, Dr. Gupta served as the Health Commissioner of West Virginia under both a Democrat and Republican governor, and led the state's response to this horrible drug epidemic that we have in our state and all across our country. Dr. Gupta, as you can tell, has also received bipartisan support from myself and my friend and my colleague, Senator Capito, also from Republican Governor Justice. Both have touted, and we all have touted, his valuable contributions to battling the drug epidemic in our home state. I myself, when I was governor, had the honor of working with Dr. Gupta, and he served as the director of the Kanawha County Health Department so many times during this horrible ravage of opiate overdose and the epidemic we have going on in the state. He would talk and converse with me, and we would talk together about how we would approach this problem, how we could overcome this problem. And he did so many things and been such valued friendship to help me through the most difficult times of fighting this horrible scourge on our state. As a primary care physician, Dr. Gupta intimately understands the needs of communities across America, and he'd be the first physician, as you've noted out, Dr. Durbin. Dr. Durbin. Well, why not? We're in the neighborhood. Senator Durbin, as you noted, that he would be the first to hold this position as a physician. As a commissioner of the West Virginia Bureau of Public Health, Dr. Gupta saw firsthand the devastation that the opioid epidemic has unleashed on the communities and led statewide efforts to tackle the drug epidemic. His work leading efforts to combat drug epidemic in a state with one of the worst overdose states rates in the nation, where we lost 1,377 West Virginians to fatal drug-related overdoses just last year, 1 year, makes him well prepared to lead similar efforts on a national scale. I don't think a better person who's had up front, on the front line of fighting this epidemic would ever be better prepared than Dr. Gupta. We have lost 93,331 Americans in the last year alone. In 2017, he was even named West Virginian of the Year as a result of these efforts that he's been fighting. So he is a dedicated public servant. He has served West Virginians admirably throughout his time as a health commissioner. I'm proud to introduce him, along with my colleague, Senator Capito. Strongly support his nomination to be director of ONDCP, and I urge my colleagues on both sides of the aisle to support Dr. Gupta's nomination and look forward to working with him, and I look forward for you all to get to know him better, because I guarantee you it'll be a pleasure. Thank you.
Thanks, Senator Manchin, and thanks for conferring a degree on me at this hearing.
As if you needed another, sir.
I definitely do not deserve. I'm reminded of an old friend of mine who used to say, I just missed the dean's list by 2 grades, A and B. Thank you for your testimony. Senator Capito.
Thank you, Chairman Durbin. Thank you, Ranking Member Grassley, for having us here today to talk about a good friend to both of us. Dr. Gupta, you could not have a better nominee for the director of ONDCP, I don't believe. As Senator Manchin mentioned, he's joined by his wife, Seema, who was a physician at our CBOC, veteran CBOC in Charleston. And when I visited there, they were sorry when the Guptas decided to come to Washington to lose her. And then, of course, their twin sons, Arka and Drew, who obviously are exceptional, but they were wonderful top graduates of the high school where is in my district, George Washington High School. So the Patriots are very proud of those boys. I first met Dr. Gupta in 2009 when he moved to my hometown of Charleston, West Virginia, to become the Director and Health Officer at the Kanawha County Charleston Health Department. I learned some things in researching to see what I would say today that I didn't know about Dr. Gupta. He was actually born in India and raised in Maryland in the suburbs of Washington, D.C. By the time I met him, he already had an impressive resume of academic and medical accomplishments. At age 21, he completed medical school at the University of Delhi and subsequently did his internship and residency at St. Joseph's Hospital, Northwestern University in Chicago, Illinois. He earned a master's degree in public health from the University of Alabama, Birmingham, and a global master's of business degree from the London School of Business and Finance. He's obviously a perpetual learner. Prior to his position in Charleston, he also was on academic faculty in Tennessee and Alabama. In 2014, Dr. Gupta and I were boarding a plane to fly home to Charleston, West Virginia. We did not realize at the time we had heard a story about a chemical leak into the water supply system of our hometown of Charleston, West Virginia. Well, we weren't sure of the aspects of it. I remember he and I talking as we were getting on at then a prop plane to fly home. And Dr. Gupta really led the public health response to this chemical spill, which really led us to not be able to drink our water for 6 to 8 weeks with a mysterious chemical that we weren't really sure what it was. So I'm forever grateful for his leadership, not just working with West Virginians, but also with the CDC to help us to realize the best kind of response in a water crisis situation. He was then appointed, as Senator Manchin said, to the Bureau of Public Health. He has served 2 governors, as Senator Manchin. I keep wanting to call you Joe. As Joe said, and you're still Joe and Shelley, yeah. So anyway, throughout his career, he's done so much, but I think nothing more than what he's done in the area of that would be covered under the National Drug Control Policy. He understands the crippling effect of addiction. Our state has been hard hit, especially hard hit, and he is uniquely, I think, situated to use this knowledge to serve our nation. And I congratulate President Biden on this nomination. It's just exceptional. As Senator Manchin mentioned, our governor is very much in support. He has said that Dr. Gupta led the way in our battle against the opioid crisis, something that has and continues to touch the lives of nearly 1 of our residents in some way. Under his leadership, our state had turned a corner, and there's so much more to be done. The head of our local Kanawha Charleston Board of Health, Jeremy Nelson, also said we believe Dr. Gupta's record of excellence in public service at both local and state levels makes him well suited to serve as the nation's next drug czar. Also, from even our national, there's a lot of support from our national folks, and I will echo those sentiments as well. We got a lot of visits from Jim Carroll and Michael Botticelli, who were the former drug czars at ONDCP. We know Dr. Gupta will visit West Virginia frequently, and we need the attention not only because we have a lot of the solutions in West Virginia that I think can serve and help the nation tackle this difficult problem. So I am confident that President Biden has submitted a nominee who will continue to do the good work of his predecessors. I know he will visit West Virginia, and please note he has on a gold and blue tie in honor of our state. He brings a wealth of real-world experience necessary to confront the realities of today's addiction crisis and to resume the progress our nation was beginning to see pre-pandemic. So I join with Senator Manchin today. It's no accident that we're both here. I think that it's a tribute not only to Dr. Gupta, but it's also a tribute to Dr. Gupta's dedication to to make sure that every public servant in our state was aware of what he was doing, the challenges he was facing, and how we can help. So congratulations to Dr. Gupta. Again, I thank President Biden for this excellent nomination.
Thanks, Senator Capito and Senator Manchin. Appreciate your attendance this morning. We're going to change the name plates, and we're going to invite Justice Robinson and Ms. Sung to come forward to be sworn as soon as we get the housekeeping out of the way. If you'll please raise your right hand. Do you affirm the testimony you're about to give before the committee be the truth, the whole truth, and nothing but the truth so help you God? Let the record reflect that both witnesses answered in the affirmative. Justice Robinson, please proceed with your opening remarks. You have to push the button. Don't light up the light.
That's not indicative of my ability to follow the law and directions in a general sense. Thank you, Chair Durbin and Ranking Member Grassley. I appreciate the opportunity to appear in your committee. And I want to acknowledge my deep gratitude to President Biden for the confidence he's placed in me with this nomination. Senator Leahy and Senator Sanders, I'm deeply moved and honored by your exceptionally generous introductions. Thank you for your support. I've been blessed with a large and wonderful family, including my parents, 4 older siblings, siblings and parents-in-law, 15 beloved nieces and nephews, aunts, uncles, and 21 cousins and their own spouses, kids, and grandkids, all of whom are part of my circle in life. My sprawling clan is well represented by the 3 behind me. My parents, Bob and Cindy, recently celebrated their 69th wedding anniversary. They've given me unwavering support throughout my life and have always taught me that the measure of success is what you give to the world, not the other way around. My father couldn't be here, but I'm grateful that my mother made the trip from Indiana to join me today. I'm likewise grateful that my sister Barbara has made the trip from Minnesota to stand in for all the folks who would love to be here. And I'm joined by my life partner of nearly 29 years, my wife, Kim. Without her decades of support, I most assuredly would not be here today. For the past decade, as a justice on the Vermont Supreme Court, I have done my best to interpret and apply the law even-handedly, consistent with precedent, statutes, and the Constitution that binds me. I would be honored to continue my work promoting the rule of law as a judge on the Second Circuit. Senators, I'm well aware of the awesome responsibilities that the members of this committee juggle every day, and I truly appreciate all of your service. I look forward to answering your questions. Thank you.
Thank you very much. Ms. Sung, please proceed.
Thank you, Chair Durbin, Ranking Member Grassley, and all of the committee members for this opportunity to appear here today. Thank you to Senators Wyden and Merkley for your support and the very kind introductions. Thank you, President Biden, for the tremendous honor of this nomination. I am humbled to be nominated to fill the seat of the Honorable Susan Graber, who has served the Ninth Circuit with the utmost integrity and distinction since 1998. Here with me today are my wonderful husband, Ryan Meehan, and our daughter, Maeve, our bringer of great joy. I cannot thank them enough. Also with me is my brother, Jeffrey Sung, a proud Army veteran. I thank him for his service and his support throughout this process. I would also like to thank all the family, friends, and colleagues who could not be here, including my stepson, Nico, my sister-in-law, Sue, my nephews and niece, Lincoln, Declan, and Malia, my mother-in-law, Janet Meehan, and my father-in-law, Ken Meehan, whom we sadly lost last year. To my parents, Stephen and Cheryl Sung, I owe a special debt of gratitude and love for all that they have given so that Jeff and I could pursue our American dreams. And finally, I pay respect to all of my grandparents, each of whom faced great challenges with great courage and integrity. My family instilled in me a deep appreciation of how fortunate I am to be an American, to grow up in a country where our fundamental rights, like the freedom of religion and speech, are guaranteed in our Constitution and enforced in our courts. And for this reason, it would be the highest honor of my professional life to serve my country as a judge and share the awesome responsibility for upholding the Constitution that we all cherish. Thank you for considering my nomination.
Thank you very much, Ms. Sung. Let me start the questioning. You've been an appointed member of the Oregon Employment Relations Board since 2017, and as it's commonly known, the ERB is a 3-member panel representing diverse perspectives on labor and employment issues. Of the approximately 200 matters you've presided over, you've ruled in favor in some instances for employers and other instances for employees. As a member of that board, you analyze the record and case law and try to be a neutral adjudicator, I'm sure. You also work with your fellow board members to try to find consensus where possible and to collaborate on draft language. What have you learned from that experience that you think will help you as judge in the Ninth Circuit?
Thank you for the question, Chair Durbin. As you noted, I've served as a neutral adjudicator for nearly 5 years, and I serve on a 3-member panel issuing decisions. And that panel is professionally diverse by design. And I think that experience has especially deepened my appreciation for collegiality. I work hard to reach consensus whenever possible, and the vast majority of our decisions are unanimous. And I believe that experience will serve me well as an appellate judge, should I be confirmed.
Ms. Sung, in July of 2018, as a Yale Law School alum, you signed on to a letter to Yale Law School leadership expressing concern about then Judge Kavanaugh's nomination to the Supreme Court. Would you like to comment on that letter in light of your nomination?
Yes, thank you again, Chair Durbin. The letter that you referenced was addressed only to my law school administration, and I signed it strictly in my personal capacity as a private citizen addressing my alma mater. I did not write the letter, but I recognize that much of its rhetoric was overheated. And if by signing that letter, I created the impression that I would prejudge any case or fail to respect the authority of any Supreme Court justice or any of the court's precedents, then I sincerely apologize. Throughout my legal career, as a litigator and as an adjudicator, I have respected the authority of every Supreme Court justice, and I have followed all of the court's precedents without reservation, and I would continue to do so as a lower court judge if confirmed.
Thank you. Justice Robinson, you've been on the Vermont Supreme Court for 10 years. Before that, in your private practice, you were a policy advocate. So obviously, we'd like to hear your comments about how those policy positions and your advocacy might impact your impartiality as a judge. Button.
Thank you, Senator Durbin. Appreciate the question. 10 years ago, I did make the transition from advocate to judge. And it was a major transition in at least 2 ways. As an advocate, my focus was the interests of my individual clients, and that was my duty and commitment. As a judge, my duty and commitment is to the law, without regard to the interests of any particular clients or even my own personal predilections. The other difference is that as an advocate for policy matters, I was very much a political person at that phase in my life. Upon assuming the bench, that aspect of my life ended because there's no space for a politically oriented person on the bench. And so for the last decade, that prior part of my life, of which I'm very proud, but it ceased to guide my work upholding the rule of law. The thing that made that transition easy for me is that I feel the same passion and commitment to my mission in this position, which is to uphold the rule of law, as I felt for any cause I advocated in the last chapter of my career.
I take it from the kind words and support you receive from so many diverse backgrounds in Vermont that you've been able to stick with that basic principle for 10 years on the Supreme Court of that state. So I acknowledge that you have 10 years of proof that you can divorce a former life of policy advocacy to a new responsibility. I thank you for your being here today. Senator Grassley.
Yeah. Ms. Sung, I was going to ask the same question that Senator Durbin did about the letter you signed. I'm not going to ask you to speak more about it, but I just want you to know why I was concerned about that, because I think it doesn't show the temperament that we should expect from judicial nominees. You don't have to comment any further. So I'm going to go to my next question. Your career has primarily involved civil litigation and labor law. Do you have any experience in criminal law?
Thank you, Ranking Member Grassley. As a Ninth Circuit judicial law clerk, I dealt with nearly the full range of issues that are presented to the circuit, including criminal and habeas matters. And I'm confident, based on that experience, as well as other experience I have had as a litigator and as a neutral adjudicator, that I can quickly get up to speed to any criminal matters or other matters that may be presented to me if I am confirmed.
You might give the same answer, but I'm going to ask this question in regard to immigration, because Ninth Circuit has so many immigration, heavy load of immigration cases. Please tell me your experience in handling immigration cases. Specifically, how many cases have you personally been involved in involving immigration matters?
Thank you again, Ranking Member Grassley. And as you anticipated, I did have a great deal of experience dealing with immigration cases as a Ninth Circuit judicial law clerk. And as well as in employment law, there is some intersection with immigration law.
Okay. I'm going to go to Ms. Robinson. I'm going to give you a question, then I'm going to give two quotes from something you said or wrote, and then I'm going to ask the question again, just so you can be ready. What is the role of a federal court in making law and catalyzing social change? So on a panel before the Vermont judicial system, you suggested that the judiciary has a role to play in making laws. You said that, quote, "Don't enact laws is not quite the same as don't make laws." On an ABA panel, you once said, quote, "Court decisions don't simply provide the remedy ordered in a particular case, they can catalyze broad social and legal change." So then the question again, what is the role of a federal court in making law and catalyzing social change?
Thank you, Senator. The role of the federal court is to interpret the law and apply it to the facts in the record in the case before it in an individual case. I'm not familiar with the specific, I am familiar, but I don't remember the context of the exact quotes you read. I have, in public speaking about the role of courts, tried to educate folks about the fact that in state courts, we have common law, which is judge-made law, and it's something that people whose only education about the court system comes from the federal hearings don't realize. I don't know if that was the context, but it may have been.
The Second Circuit, also for you, the Second Circuit is known for having significant number of security class actions, antitrust cases, and other complex commercial cases. Can you tell us about your experiences handling these types of cases?
I can tell you, Senator, that one of the things I've learned about myself during my 10 years on the Vermont Supreme Court is that I love learning new things, and I actually enjoy complexity. I enjoy trying to figure out complex questions of law, maybe if the brief makes it more confusing. Those are the kinds of challenges that I enjoy, and I think that that will serve me well on the Second Circuit.
Okay. Back to Ms. Sung, this will be my last question. How many cases have you personally argued before the Ninth Circuit, and how many briefs have you filed with the Ninth Circuit?
Thank you for the question, Senator. In my career as a litigator, I argued and filed briefs in one case before the Ninth Circuit.
Okay. Thank you. I yield back my time.
I just ask our witnesses to get as close to the microphone as you can so you can be heard by everyone. And I turn the floor over to Senator Leahy.
Thank you, Mr. Chairman. You know, I love this committee, having served on it for some time. I enjoy the hearing the various nominees. And Justice Robinson, obviously I have a personal connection as a Vermonter to your nomination, but I have a hard time remembering people came to this confirmation hearing with such a truly impressive set of supporters from across the political spectrum. Vermont's Republican governor, multiple sitting and former Vermont Supreme Court justices appointed by both Republicans and Democrats, former Republican legislators in the state, others. The letters I've had have been so impressive that have come in supporting you because I know these people and I know they go across the political spectrum in our state. How have you managed to garner this much support from leaders and colleagues, especially reflecting such a diverse ideological spectrum? What's your secret? Because I'd like to try it.
You're kind, Senator Leahy, and I appreciate the question. I treasure the sense of collegiality in the Vermont community among leaders across the political spectrum, and I have felt privileged to be a part of those conversations. The law is complicated. Policy is complicated. There are a lot of hard questions out there, and I believe that we accomplish our best results when we come together across the spectrum and truly engage with one another. And I hope that that's been the experiences of folks that I've had the opportunity to work with in Vermont.
Thank you. Like so many of the men and women who have been nominated to our various courts of appeals, you've had a long and proud record of advocacy on behalf of certain causes. Would that change your ability to serve as an impartial judge in the Second Circuit, or do you feel you can be an impartial judge on the Second Circuit?
Thank you, Senator Leahy. I hope that a fair read of my record for the last decade as I've served on the Vermont Supreme Court reflects my commitment to judging fairly and impartially and my departure from my prior phase of my career as an advocate. And I would expect to bring the same sense of commitment to the rule of law if I were confirmed to serve on the Second Circuit.
Could you just kind of elaborate on that? Because you have had 10 years as a Supreme Court justice. You've had to hear cases of a multitude of things. You've had to serve with other colleagues that come from a variety of political and academic backgrounds. What kind of lessons did you learn that would teach you to be impartial?
Well, I think we have to recognize that all of us bring ourselves to the business of judging and the responsibility of judging. We bring our background, our experience, and our attitudes. But our challenge and our responsibility as judges is to transcend that and interpret and apply the law in a way that is reflective of the law's commands. And one of the many checks and balances built into the legal system to help us overcome our individual perspectives is the give and take amongst judges on an appellate court. And I've always treasured that. I have tremendous respect for my colleagues past and present on the Vermont Supreme Court. And I have no doubt that I've been a better judge because of what they've taught me in difficult cases that we've confronted together.
Well, you've also served as chair of the Vermont Access to Justice Coalition. That's a partnership between the Vermont Supreme Court and legal aid providers to bring meaningful access to Vermont's justice system. You've participated in the Vermont Supreme Court's On the Road series, which I wish they had when I was practicing law. You've held hearings in communities across Vermont to increase transparency. How are these kind of things important to the way judges carry out their duties? And that'll be my last question. And I apologize to Ms. Sung, but I strongly support her nomination. Go ahead.
Thank you, Senator. I think it's important as judges that we find ways that are appropriate to engage in the broader community, the broader legal community, and the broader community at large. And those are examples of ways in which our court as a whole and myself and my individual committee work have tried to be part of the Vermont legal community and make the kind of systemic change that we don't make in our adjudicative role when we decide individual cases.
Thank you very much.
The next Republican senator by order of arrival is Senator Cotton.
Thank you. Justice Robinson. I think I know the answer to this since you've been on the court for the last 10 years, but I'd just like to ask you a couple questions. Have you ever represented, before you were a judge, a terrorist at Guantanamo Bay?
No.
Have you represented any client in any matter related to terrorism?
No.
Ms. Sung, same two questions. Have you ever represented a terrorist at Guantanamo Bay?
No, Senator.
Have you ever represented any client in a matter related to terrorism?
No, Senator.
Thank you both. So Ms. Sung, you're nominated in the Ninth Circuit Court of Appeals. The Ninth Circuit has a bit of a checkered track record at the Supreme Court. The Supreme Court has taken more cases from the Ninth Circuit than any other case or any other circuit, and its batting average over the last few years has not been great. 4 out of 5 cases from the Ninth Circuit have been reversed in recent years by the Supreme Court. That's gotten somewhat better after the judges nominated out there over the last administration, but still it's not great. If you are confirmed and the Supreme Court issues a ruling in any case, will you faithfully apply that Supreme Court precedent?
Without reservation, Senator.
Thank you. I want to return to the letter that Senator Durbin referenced about the nomination of then Justice Kavanaugh. You signed that letter in the summer of 2018. You said in your answer to Senator Durbin that you only signed it, you didn't write it. You don't draw a distinction, though, between writing a letter and signing on to a letter written by someone else, do you? If you sign a letter, do you believe that you're responsible for the contents of the letter?
I certainly take responsibility for signing the letter, Senator.
And that would be the case as well on a panel of judges in the Ninth Circuit. Even if you don't write the opinion, if you sign on to it, you're responsible for the reasoning in it.
Yes, Senator.
Okay, you also said that some of the rhetoric was overheated, with which I agree. Let's just explore some of that rhetoric. You said that then Judge Kavanaugh was, quote, a threat to the most vulnerable, and you also thought that he was, quote, an intellectually and morally bankrupt ideologue, end quote. Could you explain why you thought Brett Kavanaugh was a morally bankrupt man?
Thank you for the question, Senator. As I explained, I recognize that those statements were overheated rhetoric, but they were rhetorical advocacy. And if by signing the letter, I created the impression that I would fail to respect Justice Kavanaugh's authority as a Supreme Court justice or any of the justices' authority or their precedents, then I do sincerely apologize. But I can commit to you today that I would, if confirmed, as I have throughout my career, I would respect all of the court's precedents without reservation.
When the authors of that letter, or whoever it was that contacted you to sign it, present it to you, did you have even a moment's thought to say, whoa, let's hold on. Like, we can say we disagree with Brett Kavanaugh, that's fine. That's within the bounds of civilized discourse. But to call him morally bankrupt, that really is inappropriate. We should take an editing pen to that.
Appreciate the question, Senator. As I stated before, I simply signed the letter. I understood that the statements were rhetorical. When I signed it, I believed that the only intended audience was my law school administration. I believe they would understand those statements to be rhetorical. But as I said, I do apologize if by signing the letter, I created the impression that it would be anything but impartial and fully respectful of the court's authority.
Another statement in that letter was that, quote, people will die if he is confirmed, end quote. Has anyone died as a direct result of Brett Kavanaugh being confirmed to the Supreme Court?
Thank you for the question, Senator. As I stated before, I understood those statements to be rhetorical advocacy only. And I do understand that I have to take responsibility for signing the letter, but I would like to assure you, the public, and every Supreme Court justice that I do respect the authority of the court, of every justice duly confirmed sitting on the court, and I would follow without reservation all of the court's precedents.
So you can't point to someone who's died over the last 3 years as a direct result of Brett Kavanaugh being confirmed, as that letter predicted?
No, sir.
Okay. And just to be clear, so if the Supreme Court issues a ruling, whether that opinion is authored by Brett Kavanaugh or Stephen Breyer or Clarence Thomas, you will treat it with equal weight and you will follow it if you're confirmed in the Ninth Circuit.
Absolutely, Senator.
Thank you.
Senator Feinstein.
Thanks very much, Mr. Chairman. Justice Robinson and Ms. Sung, I noted in reviewing your backgrounds that you both have significant experience in deciding legal disputes. Justice Robinson, you have served for more than a decade on the Vermont Supreme Court. And Ms. Sung, you have also experience in deciding legal disputes through your service as a member of the Oregon Employment Relations Board. Here's the question. I'd like each of you to please speak on what you have learned about deciding legal disputes as a result of your experiences. Please.
Thank you, Senator Feinstein. One thing that I've learned is that when a case comes in, you might have a preliminary hypothesis about how it's going to be resolved, but there's no substitute for drilling down into the record deeply, reading all of the facts, researching the applicable law, and then conferring with your colleagues. And as often as not, your initial impression may prove ill-founded. It's one of the reasons why it's important to approach every case with an open mind and do the work to ensure that your legal reasoning is sound.
Thank you.
I'm not sure I could state it better than Justice Robinson.
Could you speak into the microphone?
Sure. I said I'm not sure I could answer the question better than Justice Robinson, but certainly my experience as a neutral adjudicator on the board has taught me the same lessons and the importance of approaching each case with an open mind, diligently reviewing the record and reviewing the law, and collegially conferring with my board colleagues before reaching any final decision. And I have benefited greatly from those conferences with my colleagues, and I would approach judging in the same way as an appellate judge if confirmed.
I'd like both of you to answer this quick question. You have both served as litigators and as such zealous advocates. How do you see that changing as a federal judge? Judge Robinson?
Senator Feinstein, thank you. I've had the experience for the past decade of playing a different role in the legal system, and one about which I am every bit as passionate as I ever was as an advocate. And I think we need advocates in our system. We need good advocates. We need robust legal argument and research. But in the end, I feel that I found my home in the judicial role, and I'm grateful to have had the opportunity to serve as I have.
Thank you. I addressed you as judge, and it should be justice, so I want to apologize for that. Please go ahead, Ms. Sung.
Thank you, Senator. I left behind the role of an advocate 5 years ago, and as a neutral adjudicator, the role could not be more different. As an adjudicator, it is my duty to consider the arguments of all the parties, to neutrally and impartially apply the law to the facts as established by the evidence in the record, and to go where the law and the facts lead me, and not without favor to any party. And I will continue to do that if confirmed.
Justice Robinson, I was impressed to see that during your decade of experience serving the Vermont Supreme Court, In one of the cases from earlier this year, you joined an opinion that upheld Vermont's ban on large capacity gun magazines under the state constitution. Can you describe how you would approach this issue as a Court of Appeals judge?
Thank you, Senator. And I'd like to be clear that the case you're describing was a case in which the court was applying the Vermont constitutional protection for the right to bear arms. So nothing about that decision purported to address the Second Amendment of the United States Constitution. The court did conclude in that case, and I joined the opinion, that Vermont's state constitutional right to bear arms does include an individual right to bear arms for the protection of self, family, and home. That's a conclusion that resonated with the conclusion that the U.S. Supreme Court reached in the Heller case with respect to the Second Amendment.
Thank you very much. Thanks, Mr. Chairman.
Senator Cruz?
Thank you, Mr. Chairman. Welcome to the nominees.
Thank you.
Justice Robinson, let me start with you. I am concerned about your record, both as an advocate and as a justice, that it demonstrates a marked hostility towards religious liberty. When you were in private practice, you wrote a brief in favor of forcing the Baker family, a Catholic family that owned a print shop, to print membership cards for a pro-abortion activist group. The Baker family believed that was in violation of their deeply held religious convictions. In your brief, you used strong and even incendiary language to describe the Baker family's religious convictions, referring to their views that they did not wish to actively advocate for and promote abortion. You referred to those religious views as invidious and pernicious. As you know, the very first clause of the First Amendment of the Constitution protects religious liberty. Given that history of litigating and attacking an exercise of religious liberty, how might a litigant in the Second Circuit have any confidence that as a judge you would actually follow the law and in particular honor the religious liberty protections in the Constitution?
Thank you, Senator Cruz. Just to put that case in context, and I don't have all the details in my mind because it was 30 years ago. It was my very first year of practicing law in Vermont. But the claim by my client was that she had been subject to discrimination on the basis of her religious conviction. In particular, she had asked to print cards for Vermont Catholics for free choice. Her contention was that the Bakers said, "We won't print these cards because we don't think Catholics can be for choice." She brought a claim for discrimination on the basis of creed, and we acknowledged out of the blocks that if the facts showed that the Bakers declined to print the placard because of their opposition to abortion rather than their belief that her strain of Catholic faith was wrong, then she wouldn't have a claim.
So hold on a second. I have to say you said that clarifies things, but if anything, that makes it worse. So your argument was that if their view was this is the teaching of the Catholic Church, then that the courts should straighten them out and say, no, you don't get to have your own understanding of the teaching of the Catholic Church. We're going to force you to say the Catholic Church is pro-abortion even if you don't believe it is. Is that right?
Senator, the applicable law as stated by Justice Scalia in his opinion in the Smith case was and remains that a neutral law of general applicability applies without...
and that's why Congress passed the Religious Freedom Restoration Act.
I understand that.
The overwhelming bipartisan majority of Congress concluded the Smith case did not adequately protect religious liberty. You likewise, during a marriage law symposium, said, quote, "Long after every state in this country allows same-sex couples to marry, there will still be churches that decline to recognize or celebrate same-sex marriage. And we're not suggesting that should be otherwise. Well, maybe it should be otherwise, but that's not our mission." I find it quite astonishing as an advocate that you're suggesting that the law has purview to force pastors and priests and rabbis to change what they teach as a matter of faith if it does not fit a political position that you happen to support.
Senator Cruz, I would agree with you. That is not my position. I'm not familiar, as I sit here, with the exact context of those remarks, but when I was an advocate, our position was always that the debate about whether a particular religious community should or shouldn't recognize marriages between same-sex couples was for the members of that religious community to decide. The question of whether the law should recognize marriages between same-sex couples was the only issue of concern for our advocates.
Ms. Sung, do you believe Justice Kavanaugh is intellectually and morally bankrupt?
Senator, I would want every Supreme Court justice to know, including Justice Kavanaugh, that I respect completely their authority as a Supreme Court justice. I would follow their precedents without reservation.
Okay, you're an experienced lawyer. You know when someone's not answering a question. My question was simple and straightforward. Do you believe Justice Kavanaugh is, quote, intellectually and morally bankrupt?
Thank you for the question, Senator. As I stated earlier, I recognize that that statement was overheated rhetoric, and that's all that it was.
Okay, I'm going to try one more time because you signed your name to it, and it wasn't decades ago. It was very recently. You signed your name to this statement. I'm asking simply today, do you believe that Justice Kavanaugh is, quote, intellectually and morally bankrupt? You signed your name to that proposition. Do you still believe it?
Thank you for the question, Senator. As I stated, that was rhetorical advocacy only, that I signed strictly in my personal capacity as a private citizen addressing my alma mater. And throughout my legal career as an litigator, as an adjudicator, I have followed all of the court's precedents.
It is disappointing that you refused to answer that question. It's a simple yes-no question, and 3 times you've refused to answer it.
Thank you, Senator Cruz. Senator Rono?
Thank you, Mr. Chairman. I ask all nominees who come before any of my committees the following 2 initial questions, which I will ask of both of you. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature? Justice Robinson?
No.
Ms. Sung?
No, Senator.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
No, Senator.
Thank you. Justice Robinson, in the past, you have discussed how courts don't live in a vacuum and are responsive to public opinion, but you have also talked about the limitation of the court, no agenda setting, and the limited ability to weave love and compassion into work. So can you tell us about the role of public opinion or personal experiences in judicial decision-making and what role it has and what role it should have, since you have said that judges don't live in a vacuum?
Thank you, Senator. I think in our constitutional democracy, the courts have primary responsibility for the constitutional part. I think the elected branches are also responsible for ensuring that their acts comport with the Constitution, but that's where the democracy, part of our constitutional democracy, lives. So in deciding cases, I don't think it's the role of the courts to think about how popular or unpopular our decision will be in a particular case. And in my time on the court, I've been part of decisions that I knew would be unpopular, and we made the decisions because they were the decisions we felt the law compelled us to make.
So I'm trying to, okay, well, I am of the view that that judges don't get on the bench and forget about all their life experiences, and that they are not just blank slates. And there are many times when in interpreting a law, which you have to apply to the case, to the facts of a case, yeah, I think your experiences do come into play. But for anyone to say otherwise, as many of our nominees previously have said, I think that is really kind of unbelievable. I'll leave that. You also have a long record advocating for LGBTQ rights, including same-sex marriage, and you also have gone out of your way in your statements to defend a faith community's right to set their own rules on who may marry. And you were asked about your approach to religious freedom just now, and you were instrumental, for example, in including protections in a Vermont marriage equality bill, protections that were requested by religious leaders. Why was it important to address or protect religious liberty with respect to LGBTQ rights?
Thank you, Senator. The discussion that you're referencing was, again, in my last role as an advocate, and it was part of the legislative give and take in Vermont legislature's enactment of the first bill in the country, law in the country that extended marriage to same-sex couples, not as a result of a court decision. I've had one opportunity to deal directly with the First Amendment issue in my time on the bench, and in that case, it was a case that involved the question of whether a grant program that provided grants to community organizations that serve the community was off limit, whether a local church that served as a community center was off limits for that grant program. And following the United States Supreme Court's decision in the Trinity Lutheran case, we concluded that it was in the context of a preliminary injunction, so it wasn't a direct decision on the merits, but that the claimants saying that the grant couldn't be made were faced steep headwinds in their claim.
I would say that you do not have a hostility to religious liberty. Mr. Chairman, I would like to ask a few questions of Ms. Sung, so if I could just go over just a little bit with your indulgence, I'd appreciate it. Thank you. So, Ms. Sung, I note that you said that you left behind the role of advocate when you joined the board. I think that is very significant because you have been asked questions about the letter that you signed on to. And so I do appreciate the fact that on this board where you have a lot of contentious cases, because whenever you have employees and employers or management and the employees or unions, it tends to get very contentious. And I note that the other two members of the board have cited your ability to be very fair in how you come down on these kinds of very contentious, although they can be somewhat boring. No offense. I've had to deal with some of those issues myself in the legislature. But I think it is also significant that that they have noted that you have an ability to be very fair and open-minded in how you decide your cases. I also would like to note that you have a lot of support from communities of color, and you would be only the third AAPI woman on any federal circuit. It's kind of astounding that there are only 11 AAPIs serving out of a total of 179 authorized federal appellate court judges. How important is diversity to the federal court system, do you think?
Thank you for the question, Senator. I think that diversity of all kinds is important to our federal judiciary because it enhances the public confidence and trust that the judiciary as a whole is impartial and well-balanced. And I think I sit on a board that is professionally diverse by design. And I know from speaking with the stakeholders that are affected by our decisions that their trust in our board's impartiality is greatly enhanced by that diversity on our board, and as well as our collegiality. I think that we work hard to reach consensus whenever possible, and that also inspires public confidence in the impartiality of our decisions.
Thank you. I couldn't agree with you more. Mr. Chairman, with your indulgence, I would like to ask unanimous consent to introduce into the record a letter that I have from NAPABA, the National Asia Pacific American Bar Association.
Without objection, it'll be entered into the record.
Thank you.
Thank you very much, Senator Rono. And I believe that Senator Tillis, by order of arrival, is next up on the Republican side. Senator?
Thank you, Mr. Chair. Thank you both for being here, and congratulations on your nomination. Judge Robinson, you responded to Senator Hirono's question about, you said in your opening statement, I believe, or in response to Senator Durbin's question, how you had a political life and that you flipped the switch and became a judge. You want me to get that for you? And you responded in a way that said that you couldn't really allow your past political positions to influence matters of law. I'm not sure that that satisfied Senator Hirono, but it did satisfy me. You also said that there were some cases that you ruled that you knew were potentially unpopular. Can you think of any cases where, as a matter of law and the facts in the case, you came down on a position that may have differed from the position you would have taken in the political chapter of your life?
I can't think of a case specifically that conflicted with, I think what you're describing with the political chapter of my life. It's not uncommon at all for all of us on the court to express to one another that this is a decision that we feel compelled to make, either because of the law or because of the record that comes up to us from the trial court, which makes findings that, as we review the record, may not have been the findings we'd made. And I'm not, as I sit here today, able to start naming specific ones, in part because I think as a sitting judge, it would be imprudent for me to tell you, oh, I made this decision in this case, but I wish I didn't have to.
You also mentioned, I think, in one case about a religious freedom matter where you were sympathetic, I believe, to the religious leaders who were trying to limit who they would actually provide marital services to. Is that true?
I'm sorry, Senator Tillis. I think that was a reference to something from the sort of advocacy chapter.
Yeah.
And I'm not entirely sure. There was, yeah, I'm not sure.
Okay, I may have misunderstood it, but I do know, I think that you were involved. Were you involved in the case, Ms. Sung? It may be you. I may get my record confused here, but it was one where you were advocating for I think it was Regal Printing. In Regal Printing, that was a case where you were actually advocating for the printing against the objections of the owners of Regal Printing.
Yeah, then this is the case that Senator Cruz and I spoke about earlier. And again, this was 30 years ago. I was brand new as a lawyer, so my memory is not, I don't want to be accountable for all the details. But the competing claims in that case was that our client was claiming that she had been denied service from a public accommodation on account of her religious beliefs. The defense was, no, we denied you service because we didn't want to print a pro-abortion thing. Oh, and we also have a First Amendment defense. We never resolved either the factual issue or the First Amendment defense because the case ultimately settled. But that was the context of the case.
And Ms. Sung, it would be, I guess, your time as you clerked on the Ninth Circuit. Or Ms. Robinson, have either of y'all had any experience with intellectual property matters? I'm the ranking member on the Intellectual Property Subcommittee. I personally think there's a lot of jurisprudence that needs to be reworked. I was just curious if you have any insights into IP matters that may come. And Ms. Sung, we'll go to you.
Not the level of expertise that would be, and not the type of experience I think that would be helpful.
I was just, with your time on the circuit, I just didn't know if maybe something had gone through your office. Ms. Robinson?
Yeah, Senator Tillis, I had occasional dabbling with copyright issues, but nothing that would caused me to think of myself as expert. I put that in the category of the type of thing I'd look forward to learning if I had the opportunity to serve on the Senate.
Well, there's a lot of work to be done, and I think Senator Leahy agrees with that. So we look forward to at least having Congress weigh into it. Just a final comment, Ms. Sung, on the letter, how long have you thought about aspiring to being a judge for some time? Or was this a surprise nomination?
I would say it's fair to characterize it as a surprise nomination.
Okay. I just think that, given I had a discussion with a nominee last night about, I don't really buy into this going back 30 years and criticizing somebody for making a ill-advised statement that maybe they regret today. But the letter does concern me because you're obviously a very well-educated, very bright person. you had to have at least assumed that it would not be viewed just in the context of a communication to your alma mater, that it would come out. And it does raise some concerns in my mind about temperament or maybe predisposition, but I'll just leave it at that. I'm not going to grill you on any questions. Thank you both for being here.
Thank you.
Thanks, Senator Tillis. Senator Blumenthal.
And Mr. Chairman, before you start, Senator Tillis and I are going to have quite an agenda on intellectual property. I'm glad you raised that issue. Thank you.
Senator Blumenthal.
Thanks, Mr. Chairman. Thank you both for your service and your willingness to continue to serve. Justice Robinson, the Second Circuit Court of Appeals is very close to my heart, having appeared before it numerous times and having great respect for the quality of scholarship and courage of many of its decisions, which I know you will continue to uphold as a tradition. And I respect your experience, nearly 1,800 decisions on the Vermont Supreme Court, which has a great tradition also of scholarship and excellence. I'd like to ask you how your experience as a litigator and an advocate has shaped your performance as a judge, because I happen to think that experience as a litigator and an advocate is important to a judge. But at the same time, obviously, you have to separate advocacy from judging. And how do you do that in terms of compartmentalizing the two experiences, but drawing on one to benefit the other?
Thank you, Senator. I think you can't be a successful litigator without being well steeped in the law and without being able to do good legal analysis. I think that practicing as a litigator is the right training ground for somebody to become a judge. You're right that the transition from an advocacy role to a judicial role is a significant one. For me, what made it easy is I was motivated as an advocate because I was passionate about the clients I represented and the causes that I advocated for. I am, as a judge, passionately committed to the rule of law and my duty to uphold it from the bench. And so I carry that same sense of mission in a different role, and that's made the transition easy for me.
And do you feel that you can separate the advocacy that you may have done? I know my colleagues have asked you this question in various different ways, but I'd like to give you another opportunity to answer it.
Thank you, Senator Blumenthal. I've written over 310 opinions. I've participated in nearly 1,800 decisions in my time on the Vermont Supreme Court. I'm quite sure that no one person in this room will agree with every position I've taken and every opinion I've written, but I hope that a thorough review of my record would support my own belief that I try in every case to be even-handed with fidelity to the law, and I try to bring rigorous legal analysis to the cases before me.
Let me ask you kind of a loaded question. You can feel free to avoid answering it, but I happen to feel we need more judges at the district court level, possibly even the circuit court level. Do you have any views on that issue?
Senator Blumenthal, I because I don't currently serve in the federal system, I'm not in a position to weigh in based on any kind of personal experience.
I thought, especially because you're not currently in the federal system, you might weigh in on it, but that's fine. Ms. Sung, tell me, what is it that you will look forward to most about being on the Ninth Circuit Court of Appeals?
Thank you for the question, Senator. I think I will look forward to most continuing my work as a neutral adjudicator in the sense of diligently reviewing cases and researching the law and impartially applying the law to the facts of the record while working collegially with other judges to hopefully reach consensus about what the correct result in the case is. Because I already serve as a neutral adjudicator, I would say that one other thing I would especially look forward to on this circuit is the opportunity to work on the wide range of issues that are presented to the circuit. I have, throughout my career, dealt with a variety of subject areas, including constitutional law, and the opportunity to serve as a judge responsible for deciding those types of issues would be a great responsibility and something I think I would particularly also enjoy.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Cruz. I'm sorry, Senator Cornyn,
The senior senator.
the senior senator from Texas.
Better looking one.
Thank you, Mr. Chairman. Judge and Ms. Sung, I want to ask you about an article. Actually, it's an opinion piece that Linda Greenhouse, longtime reporter covering the Supreme Court of the United States, wrote in the New York Times on September the 9th, 2021. The title of the article is "God Has No Place in Supreme Court Opinions." And she goes on, among other things, to talk about the court's abortion jurisprudence. And I would just like to ask both of you, do you believe that when life begins, Judge and Ms. Sung, is a religious question? Is it a legal question? Is it a scientific question? Is it a philosophical question? Or is it a political question? Or some other category that I haven't mentioned? Judge?
Thank you, Senator Cornyn. I think those are important questions, and I will say that as a sitting judge and as a nominee for the Second Circuit, it wouldn't be appropriate for me in this setting to offer an opinion as to the framework for evaluating that question. What I can tell you...
I'm not asking you in the context of deciding a case. I'm asking you what your personal opinion is about when life begins, whether it's a religious, legal, scientific, philosophical, or political question.
No, I understand that, Senator Cornyn. My concern is that if faced with a case that involved a challenge to restriction, I would be obligated to follow the precedents of the United States Supreme Court, and statements that I might make today as to how that question should be evaluated could suggest...
So you're not going to answer the question. I understand that. So the circuit that you will be sitting on will be the court of last resort for many cases. As you know, the Supreme Court of the United States only hears roughly 80 cases a year. And so you will be, in effect, sitting on the Supreme Court for all practical purposes for a number of cases. And so I think it's a fair question. Let me just ask you, under the Supreme Court's jurisprudence, and I'm asking you now as a legal interpretation, does the question of when life begins, is that relevant to a legal discussion about abortion rights?
Senator, as I read the court's current case law, viability is the touchstone of the legal framework that the court has built. I don't understand it to weigh into questions of when life begins from that perspective.
And so the question of viability or when life begins is an important legal question under the Supreme Court's jurisprudence. Do you agree with that?
Yes.
Okay. And I guess, do you know where the court, Ms. Sung, you'll be sitting on the Ninth Circuit Court of Appeals. Where does the Supreme Court look to determine the question of when life begins?
Thank you for the question, Senator. As I recall from the court's current jurisprudence on the issue, they look to scientific evidence to determine when a fetus is viable.
Would that be the state of scientific evidence back when Roe versus Wade was decided, or would that be the state of science today?
My understanding from the course of the court's jurisprudence is that it has, to an extent, recognized that scientific advances can change the point at which a fetus is viable.
Judge Robinson, do you believe that an unborn child, at any point up until the time the child is delivered by the mother, does that child have rights under the Supreme Court precedent?
I believe that the Supreme Court, in general terms, has recognized that after the point of viability, one of the interests that is within the scope of permissible regulation for the state is the interest of the fetus that would be born as a child.
Do you agree with that, Ms. Sung?
That is also my understanding of the court's jurisprudence.
So the question of viability or when life begins is an important issue because if the fetus is viable, then the fetus has rights that can be protected by the state. Correct, Judge?
Senator, in broadly general terms, yes.
No. You agree with that, Ms. Sung?
Yes.
So I won't ask you this question, but I'll just close on this. We'll maybe continue the conversation. 7 out of 198 countries in the world allow abortion after 20 weeks. I presume the basis for those decisions is when they believe the fetus is a question of viability we've been talking about here. And the United States finds itself among those 7 countries: North Korea, Vietnam, China, and Singapore, Canada, and the Netherlands. Thank you.
Thank you very much, Senator Kennedy.
Mr. Chairman, could I ask unanimous consent that this article be made part of the record?
Without objection.
Thank you.
Senator Kennedy?
Thank you, Mr. Chairman. If you could indulge me, I'd like a couple extra minutes too. It's okay.
Certainly.
Counselor, did you really say that Justice Kavanaugh was a morally bankrupt person?
Senator, as I explained, I did not write that letter. I did sign it.
Did you read it?
I read it quickly, yes.
And you
sir.
signed it?
Yes, sir.
Did you really say that Justice Kavanaugh, if he was confirmed, would cause people to die?
As I stated, Senator, I understood those statements were overheated rhetoric, but I understood them to be just
Yeah,
that,
but you said
rhetorical.
You said it, right?
I did sign the letter, yes, Senator.
Okay. Do you believe that Brett Kavanaugh is a morally bankrupt person?
Senator, sitting here as a judicial nominee, it is not appropriate for me to comment
Do you believe
personally
that,
on
well, you
any
said
justice.
it. You said it. Do you believe that he's a morally bankrupt person?
Senator, it is not appropriate for me
Why
to
not?
comment.
You said it.
I understand.
Senator, I am giving you extra time, but can she be allowed to answer?
Sure. I just want an answer. I agree that she should answer. You're not going to answer my question?
I believe I've answered it to the best of my ability. Honestly, Senator, I respect completely the confirmation process and the authority of Justice Kavanaugh and every Supreme Court justice.
But do you, this is real simple. You said just a few years ago, you weren't in law school, you weren't in college. You said Brett Kavanaugh is a morally bankrupt person. It's clear as thunder on a summer night. Now, you're under oath. Do you believe he is or not? How hard is that? You'll have much harder questions as a federal judge if you make it that far.
I appreciate the question, Senator. As I stated, those statements were rhetorical advocacy that I signed as an alum addressing my law school alma mater. I did not.
Well, let me ask you about this rhetorical advocacy. Does rhetorical advocacy mean you said something, but now that you've been nominated, you're scared that you can't get the votes, so you're going to try not to answer the question? Is that what rhetorical advocacy means? What is rhetorical advocacy? Is it a lie?
No, it's not a lie, Senator. I would say that it's statements that are made in service of an advocacy position.
Okay. And if you issue an opinion and you get reversed by the Supreme Court, are you just going to say, oh, don't worry about it, justices, that was just rhetorical advocacy? What is this?
Absolutely not, Senator. If the court issues an opinion As a lower court judge, I would be absolutely bound to follow it. It is not merely rhetorical advocacy. It is the law of the land.
Okay, let me try one more time. Do you believe that Brett Kavanaugh is a morally bankrupt person?
Senator, as
Sitting here today, under oath.
Sitting here today under oath, I can assure you that I respect completely the authority of Justice Kavanaugh as a duly confirmed Supreme Court Justice of the United States.
Yes, ma'am, but do you believe he's morally bankrupt?
Senator, as I stated, I respect his authority and the authority of every Supreme Court Justice sitting on our court.
Yes, ma'am, but do you believe he's morally bankrupt?
My personal opinion is not appropriate for me to say. I respect his authority as a Supreme Court
So
Justice.
you think he
as I
is
do
morally
for-
bankrupt?
I did not say that, Senator.
But you signed a letter saying he was morally bankrupt.
Several years ago, as an alum addressing my law school alma mater, I did sign a letter that I believed was addressed only to my law school administration.
Oh, you
But
didn't
sitting
think
here
it would be public?
I did not understand that it would be used as a public advocacy piece. No, I
Okay.
believed it was only addressed to my law school administration.
And you signed that because you wanted to show fidelity to your alma mater, Yale Law School?
I signed it, Senator, at the time because I felt that it was an appropriate statement to make to my law school administration, notwithstanding the overheated rhetoric. But sitting here today as a judicial nominee, what I want to assure you is that as an advocate, as a litigator, as a neutral adjudicator, and as a judge, if confirmed, I would absolutely respect the authority of every Supreme Court justice and all of its precedents without reservation.
See, I don't believe you. I think you allowed your political beliefs to cloud your judgment. And I think you said a few years ago what you said about Brett Kavanaugh, and I think you believe it. And I can't imagine what it's going to be like to be a litigant in front of you with that demonstration of lack of judicial temperament and judgment. How can a litigant possibly think that you're not going to act on personal beliefs if you were so intemperate to say something like this? Last question. Are you proud of the fact that Yale Law School has a quota system limiting the number of Asian Americans? Have you ever written a letter about that? Or does that not, where does that fit in your socioeconomic view of the world that you think everybody else should adopt and you will impose if you're in a position of power?
Senator, I'm not aware of any policy like that, but what I can assure you is that I have a track record.
You need to get out more.
I have a track record as a neutral adjudicator. I have decided cases for nearly 5 years impartially by applying the law as set forth in our statutes, our Constitution, and our precedents. And I have applied that law impartially. I have ruled
You're the only
without
person in the Milky Way who believes you're impartial.
Mr. Chairman,
I'm done, Mr. Chairman.
Well, yes, you are. Mr. Chairman, I'd note that it seems to be this idea that, especially if we have a woman nominee, you can interrupt her anytime you want, state your own things. She's answered this question over and over again. I would hope that we get back and show some respect to those who are answering questions under oath.
Mr. Chairman, since my name's been invoked, Senator Leahy knows how much I admire and respect him. I resent the suggestion that I'm doing that because she's a woman. I would be doing it if she made those intemperate remarks as a male. And I don't believe the senator has any evidence to show that I'm somehow being misogynistic. I have respect for the rule of law, whether it's by a male or a female. Gender has nothing to do with it.
I have respect for this committee, but I also look at the record of how the votes go on nominees. And I've seen it in my years here, which is longer than anybody else in this, I've seen a disproportionate number of votes. I'm not referencing any particular senator. You can go back and look at your own record. A disproportionate number of votes against women and people of color, especially women of color. I've seen that. I've mentioned that before without mentioning any particular senator, every senator has the right to vote as they want. But let's all stop and think of what we're doing. I've heard senators talk about, well, Democrats are against any nominee to any Republican nominee to the Supreme Court. I'd ask any senator, any Republican senator, show me a Republican senator who's voted for more Republican nominees to the U.S. Supreme Court than I have. I don't think there is one.
Mr. Chairman, let me respond to that now. Senator Leahy knows how much I respect him. And I do. More than I can, there aren't words in English. But I don't care how long he's been here. I don't think there's any evidence in this record to show that I have voted on a nominee on the basis of race or gender. And I resent that.
We're going to terminate this conversation and go back to the business of the committee. And I believe that Senator Blackburn is the next person up for questioning. Senator Blackburn.
Thank you, Mr. Chairman. I appreciate that. Justice Robinson, I'd like to begin with you. The Second Circuit is one of the most important forums for securities law, antitrust, which is an important issue we're looking at in this committee, complex commercial litigation, shareholder class actions. To date, you have participated in over 1,800 matters, but none of them, not a one, appear to be securities, shareholder class actions, commercial litigation, corporate entities, complex financial transactions. So, given this, if you were to be confirmed, what are your plans to familiarize yourself with these areas of the law?
Thank you, Senator Blackburn. It's true that I have had some cases that involve commercial litigation, more broadly speaking, but I agree that most of the subject areas you listed are matters of focus in the federal courts. I can tell you that in my 10 years on the Vermont Supreme Court, I found that, A, I really like learning new things. I like broadening my horizons, and B, I enjoy complexity. When cases come in that some people look at and say, oh my gosh, and they look at the record, I get excited. And I think that that disposition is something that would serve me well in trying to expand my knowledge on the Second Circuit.
Then let me ask you about this, judicial activism. I want to talk with you about that. You made a statement at an ABA panel where you said court decisions can catalyze broader social and legal change. So what does judicial activism mean to you, and do you think it's appropriate?
Thank you, Senator Blackburn. I don't use the term judicial activism because it has very different meanings to different people.
Okay. So then you have no answer to that.
Well, I'm sorry. I thought the question was, what does judicial activism mean to me? And I don't.
All right, but you see decisions as driving broader social change, but then you do not interpret that as being judicial activism?
Senator, I think the role of courts is to decide the cases that come before them pursuant to the law that they apply.
Well, one of the things that Tennesseans don't appreciate is having activists on the court. They want that to be a neutral body, and that's what they expect. Ms. Sung, I want to come to you, going back to this letter that you signed. What you're saying is that it is a heat-of-the-moment decision that you made, that probably you exercised poor judgment, and it's difficult for you to separate that personal from your professional as you signed that in your professional capacity. Would I be correct on that?
Thank you for the question, Senator. To be clear, I signed that letter strictly in my personal capacity.
Okay, so you did that in your personal capacity. Okay, in the letter, I want to go to this. You said that you thought he was a threat to the most vulnerable, that's a quote, and that a threat to many of us. And the letter went on to say that people will die if he is confirmed. So why don't you talk to me about who is the us that Kavanaugh is a threat to, and who are the people that you expected to die if Kavanaugh was confirmed? I mean, this is a pretty broad, brazen accusation. It's pretty out there. So why don't you bring some clarity to that?
Thank you for the question, Senator. I agree that those statements were overheated rhetoric. And as I stated before, if by signing the letter, I created the impression that I, as a judge, if confirmed, would fail to respect the
Let's
authority
do
of the
the
justice,
premise
then I
that
do apologize.
You created that. You created that perception. And many times people believe perception is reality. So you've established that as your thought process, that you, as a person, in your personal capacity, you say, not in your professional capacity, but you as a person, in your heart of hearts, you think, here is someone who is unacceptable. He is a threat to us, but you still haven't defined us. He is someone who will himself cause people to die. So if you don't want to bring clarity to that for me, then by signing that letter, have you proven yourself to be unacceptable as a nominee for a federal judgeship?
Thank you for the question, Senator. I think the best evidence of the kind of judge I would be, if confirmed, is my track record as a neutral adjudicator. As a neutral adjudicator, I have decided cases impartially by applying the law to the facts as established by the evidence in the record.
Let's talk about that. During your 11, and by the way, you've still not answered the question on this. You're kicking the can on the road, you're punting on it, and you should know that that is not something that is acceptable. And until you can clear the record on that, it is going to bring that perception to bear in how people perceive your thought process to be. So I think it needs a little bit further
Thank you, Senator Blackburn. Your time has expired.
Oh, okay, thank you. I'm sorry, my clock isn't working over here. Thank you. I have questions I'll submit to you for the record about your judicial record and the number of times you've actually been in federal court.
Thank you. I believe Senator Lee is next by order of arrival.
Ms. Sung, I wasn't originally intending to ask you about the letter. I was wanting to ask about other things. Some of your answers have me confused. When you call someone an intellectually bankrupt ideologue who is intent on rolling back our rights and the rights of our clients, you either mean that or you don't. I assume you would agree with me that if you're speaking of someone that way and you don't believe that, you don't have a reason to think that would be defamatory, would it not?
Thank you for the question, Senator. As I stated, I did not write those statements. I take responsibility for signing the letter, and I do recognize that they were overheated.
I understand that, Ms. Sung, but I'm asking, would those be defamatory if they were not true?
The definition of defamation and the standards for defamation are complicated, but they vary depending on whether someone is a public figure. They vary in terms of whether they were statements of fact and whether they can be proven or disproven.
He was, in fact, a sitting judge at the time you made the statement. And so it's not that you're pulling them from air. You were purporting to have some knowledge of it. It's not just that you said he was a morally bankrupt ideologue who would deprive people of rights. You also said people will die if he is confirmed. There's no qualifying language in there, nothing saying we fear that this might result in decisions which could in turn result in things that would be bad for people. You called him, quote, a threat to the most vulnerable. Quote, he is a threat to many of us simply because of who we are. If you were saying that of someone and you didn't believe it was true and you didn't have a reason to make such a statement, wouldn't that be defamatory?
Respectfully, Senator, requirements for defamation would require statements of fact, not mere rhetorical
People
advocacy.
will die if he is confirmed. Is that not a statement of fact? It's not couched in language of opinion. It's not couched in any logical syllogism talking about how this might lead to things. Nor is it ambiguous to say that he is an intellectually and morally bankrupt ideologue intent on rolling back our rights and the rights of our clients. So let's just start with that one. Wouldn't you agree that that's defamatory, if not true?
Appreciate the question, Senator. As I stated, when I signed the letter, I understood those statements to be rhetorical advocacy, not statements of fact.
Rhetorical advocacy is not a defense to defamation, not at common law, not under the law of any state with which I'm familiar. Can you tell me how that's relevant to my question?
Respectfully, Senator, as I stated before, I did not consider those to be statements of fact.
Then, okay, so I don't think it's a defense ever to a claim of defamation to say I didn't intend that as a statement of fact if in fact you're making statements of fact. Nor are these things just rooted in the ether. You're not purporting to draw from them in the absence of any context. You're drawing from it, apparently in the context of his status as a then sitting judge on the U.S. Court of Appeals for the D.C. Circuit. Is that not itself undermining the legitimacy of the courts? As an officer of the court, is that the sort of thing you aspire to?
Senator, as I stated, I do apologize if by signing that letter, I created the impression that I don't respect the authority of the courts or any duly confirmed Supreme Court justice. Throughout my legal career as a litigator, as an adjudicator, and as a judge, if confirmed, I would respect the authority of every Supreme Court justice. I have followed the court's precedents without reservation. I have applied them as an adjudicator, and I would continue to do so as a judge, if confirmed.
When you describe his nomination as a threat to the most vulnerable and as creating an emergency, that tends inevitably to suggest that your confidence in him is so lacking that someone would be justified in doing anything they could to undermine his judicial authority. I fail to see, as I read this letter, any caveat, any reservation, anything saying, warning, we don't really mean this. And one of two things has got to be true. Either you didn't believe these things, in which case you defamed him, or you did believe this thing, in which case I find it very difficult to believe that you're going to be able to respect his rulings, as you will be bound to respect, given that he's sitting on the Supreme Court of the United States. And I'd add, finally, Mr. Chairman, I think it's important that we be able to ask these questions, and people can have legitimate concerns about a candidate without having our motives questioned, and without having our motives questioned, particularly in the context where someone has questioned the motives of a member of the Supreme Court of the United States. I find this troubling. It's a troubling trend on the committee, and it's not one that we should aspire to continue.
Senator Lee, I believe the record will show that there have been ample opportunities to ask a question about that letter this morning. The chair has not cut off anyone, nor do I plan on it. Senator Hawley?
Thank you, Mr. Chairman. Thanks to the nominees for being here. Congratulations on your nomination. Justice Robinson, if I could just start with you, I have to say I'm troubled by your history of compelling individuals to express pro-abortion viewpoints against their religious convictions. I'm talking about the Regal Art Press case. I think Senator Cruz asked you a few questions about it. You represented Linda Paquette in 1994, who demanded that two devout Catholics print custom membership cards for an organization that advocated in favor of abortions. When they declined to do so, citing the teachings of their church, you and your client filed a complaint with the Vermont Human Rights Commission and then a lawsuit. And in your briefs, you argued that their decision not to print those materials was invidious, it was pernicious, and it was akin to racial discrimination, which is quite a claim. I mean, it's really quite a claim. And I have to ask you, why did you feel it was important to leverage the machinery of government? This is a private business. These are two private individuals. Why did you feel it was important to leverage the machinery of government to force these two Catholic business owners to violate their sincerely held religious convictions? Help me understand this.
Thank you, Senator Hawley. As I indicated with Senator Cruz, that case was 30 years ago, so I apologize if I'm not as precise about all the details. But I can tell you, generally speaking, that we conceded that if the printers had declined to print the materials on account of their opposition to abortion, that there was no basis in law to pursue our claim. The issue, the threshold issue in the case is whether that in fact was the facts. My client was a Catholic. She was there to get flyers for Vermont Catholics for Choice printed. She was deeply offended by the suggestion that she wasn't a true Catholic, and that was the reason why the printer wouldn't print the materials. The case never proceeded beyond that stage. We went up to the Supreme Court on what I would call a procedural issue. We went back down, and the case settled, and that was the end of it.
Well, I can understand the issue if the government had told your client that she wasn't a true Catholic or a true Hindu or true whatever, given our First Amendment. But we're talking here about a suit against two private individuals, husband and wife, I believe, Malcolm and Susan Baker, who on the basis of their religious viewpoints said that they couldn't print these cards. And you and your client attempted to leverage the machinery of the state. In fact, you were the ones trying to use the machinery of the state to compel these two private individuals to speak. Now, of course, the Supreme Court has addressed this fact pattern in the Masterpiece Cake Shop case since that time, which concerned compelled speech. In light of Masterpiece Cake Shop, do you acknowledge today that your client would not have the right to compel other individuals to speak in a way that she favors?
Senator Hawley, I don't read the Masterpiece Cake decision as altering the Smith holding that neutral laws of general applicability apply without regard to a free exercise defense, nor do I understand the court to have resolved the speech claim. As I read the Masterpiece Cake decision, it turned on the fact that the court concluded that the process in the Colorado Civil Rights Commission evinced hostility toward religion, and it wasn't, in fact, a neutral law of general applicability in that respect.
So I think this is an important point. So what you're telling me is your view, or understanding of the law is that the law can, in fact, compel people of religious faith to speak against their own faith and their own viewpoint. The law can do that. And if it's labeled as neutral, but it just so happens that it compels religious believers to violate their sincerely held religious beliefs, that's okay under the First Amendment. Is that correct? Is your understanding of the law as it currently exists?
No, Senator Hawley, I'm not aware that the U.S. Supreme Court has addressed the nuance of a free exercise claim coupled with a free speech claim, which is what you just described. What I referenced earlier was a straight-up free exercise claim, and I think that the U.S. Supreme Court hasn't backed away from Justice Scalia's decision in the Smith case in terms of the applicable law.
So you stand by your representation of this client and all of the arguments that you made, including calling the position of these two Catholics, Malcolm and Susan Baker, invidious, pernicious, and akin to racial discrimination? Do you regret any of that rhetoric?
Senator, I don't remember the context. I haven't looked at that brief in 30 years.
So does the passage of time make it any different? I'll give this to you for the record, and that'll allow you to refresh your memory, but I'm quoting you, invidious, pernicious, akin to racial discrimination. As you sit here, does that not trouble you? You're describing the religious beliefs of practicing Catholics who are citing the teachings of their church. You think that's akin to the Ku Klux Klan?
Senator, the threshold question in the case, which I suspect I will find is what we were addressing in that passage, was whether or not this was discrimination against my client on the basis of her religion.
And you were saying that these two Catholics who did not want to provide the speech, you're engaged in the speech your client wanted them to on the basis of their faith, doing so was akin to religious discrimination. Listen, I have to tell you, the last president sent somebody up here to this committee who made that exact argument. It's a Republican who made that exact argument. I voted no. That person didn't get confirmed. I've got profound concerns, Justice Robinson, about your position here. And I have to tell you, the passage of time doesn't do anything to alleviate my concerns. One more question, Mr. Chairman, if I might. Let's shift to criminal law. The Kozłowski case, can you help me understand this case? September term 2017, this is a defendant who was living with his girlfriend and her 6-year-old daughter. The defendant was using box cutters to open boxes. The 6-year-old asks him what he was doing. The defendant held a box cutter to the girl's stomach, told her he would kill her in her sleep, then laughed as the girl ran away. The girl later told her father about the incident, said she was unable to sleep, understandably. This same defendant later convicted of aggravated domestic assault with a deadly weapon. You dissented, saying he shouldn't have been convicted, and you wrote, in part because the blade was covered with plastic, it shouldn't have been considered a real threat, and you went so far as to analogize this to a pillow fight. I've got the case right here. You said this threat in this case is akin to the threat to use a pillow to swat somebody's backside. I have to tell you, this completely baffles me. The threat of a box cutter to a 6-year-old stomach, and the guy says he's going to kill her, and that's akin to swatting her with a pillow. What am I missing here?
Thank you, Senator. I think if the picture in your mind is the box cutter that we use to open boxes in our garage, I would understand your perception of that.
The picture is the one that is in the record because it's in the case. I can see it. It's right here. It's right here. It's a box cutter. There's a blade.
Yeah.
He put that to her stomach.
The blade was completely covered, Senator, and the question of law.
He threatened to kill her.
The question of law, well, there were two questions. One was the record and what the record showed, and I understand your description of what you understand the record to have showed. I'd have to go back and look more broadly. But the legal question is whether the definition of deadly weapon in Vermont law was satisfied by that implement. The fact that an implement may be used in a deadly way doesn't make it, by definition, a deadly weapon. And so the question involved the very specific nature of that box cutter and the way he used it.
Well, all I can say is I find your position in this case frightening. And the idea, as the father of 3 young children, the idea that somebody puts a box cutter to a young girl's stomach and says he's going to kill her in her sleep, and that's not an issue, frankly, I think that's crazy. Thank you, Mr. Chairman.
Senator Durbin has gone to vote. I will go shortly, but that concludes our first panel. We thank both of you for your excellent testimony this morning, and congratulations again to you and your families. We will now move to the next panel. Please be mindful that senators may submit written questions following the hearing, and we'll ask you to work diligently to respond to them. Thank you very much.
Thank you, Senator Blumenthal, and thank all of you.
With that, we'll move to our second panel. I'll ask for everyone's patience for a moment while we finalize the setup for these 2 nominees. Dr. Gupta and Ms. Prelager, you may take your seats. And I'm going to ask you to stand and take the oath, as is our custom. You solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Thank you, Dr. Gupta. You may proceed with your opening statement. Good afternoon, Chairman Durbin and Chairman Blumenthal at this point, Ranking Member Grassley, distinguished members of the committee. Thank you for inviting me to discuss my nomination for Director of National Drug Control Policy with you. I would like to thank my home state senators who were earlier here today, Senator Manchin and Senator Capito, for their kind introductions. I'm honored that President Biden has nominated me for this position. I would like to thank my family for their steadfast support. I'm grateful to my wife of 25 years, Dr. Seema Gupta, who serves our nation's veterans as a physician, and my twin sons, Arka and Drew, who have taken time from their studies to be here. I'm also happy to have my dear friends, Reverend John Unger, who has worked with Mother Teresa in Kolkata, India, and Brian Skinner with me. And I'm eternally grateful to my late parents, without whose blessings I would not be here today. It's a privilege to appear before you as the President's nominee and also as a practicing physician, a first-generation immigrant, and a public health official from a rural state. With decades of experience at the intersection of public health and public safety, I am ready and eager to lead the federal government's response to addiction and the overdose epidemic. And with your support, I hope to get to work as soon as possible. As you are aware, this epidemic has cost hundreds of thousands of American lives. Fueled by illicitly manufactured fentanyl, methamphetamine, and cocaine, this urgent challenge has grown during the COVID-19 pandemic. Today, there are more than 21 million Americans with a substance use disorder, yet only a fraction of physicians who have the qualifications to treat them. So it's no surprise that so many people do not know where to turn for help. As a physician, I've taken the Hippocratic Oath. I've served in towns as small as 1,900 residents and in cities as large as 25 million. As I've seen the challenges people, providers, and local communities face, as a public health official, both at county and state levels, my record reflects my commitment to addressing the differing needs of diverse populations. As West Virginia's health commissioner, I launched the first statewide social autopsy, a review of the lives of all West Virginians who died of drug overdose in 2016, and many of those findings were just stunning. 4 out of every 5 victims had a contact with a healthcare system prior to their death, and our system of care had failed to provide them timely help they needed. So we used this data to change our approach. We expanded access to naloxone to prevent fatal overdoses. We scaled effective programs to serve families, and we partnered with the Department of Corrections to provide treatment to justice-involved individuals to reduce recidivism and help people transition back into society. I also work with the Appalachian HIDA to bring the OD MAP program to the state, which enabled law enforcement and public health officials to collaborate and track overdoses across jurisdictions in real time and respond. These partnerships have been critical in my public health work, and I look forward to continuing ONDCP's strong relationship with state, local, and tribal law enforcement agencies. Over the decades, I've learned that an overdose is a cry for help, and for far too many people, that cry goes unanswered. If confirmed, I would do everything in my power to make sure these cries are heard and people receive the help that they need. My immediate focus would be to reduce and eventually eliminate overdose deaths. We must build a better addiction infrastructure centered on individuals, families, and bringing communities together, from public health to law enforcement to faith-based organizations and the private sector, so we can meet the people where they are and save lives. We must also reduce the supply of illicit substances entering our country, including illicitly manufactured fentanyl from Mexico and China, methamphetamine from Mexico, and cocaine from Colombia, and hold the drug traffickers accountable. While the Biden-Harris administration's drug policy priorities have set us on the right path, we have much more to accomplish. The challenge we face is enormous. My life's work with patients and communities has prepared me for this challenge, and I would be honored to be the first physician to lead this office. If confirmed, I look forward to working with this committee and Congress in a results-oriented,
data-driven manner to turn the corner on this devastating epidemic. Thank you for your consideration, and I'm happy to answer your questions.
Thank you, Dr. Gupta. Before we proceed, let me thank Senator Blumenthal, who's hurried off to vote. We do a tag team here when the votes are on, try to keep the committee in session because you've all waited patiently for this opportunity. And thank you for your testimony. Ms. Perlugger, please proceed with your opening statement.
Thank you, Chairman Durbin, Ranking Member Grassley, and members of the Judiciary Committee. And Mr. Chairman, thank you in particular for that kind introduction earlier. Sitting before you today, I am overwhelmed by a sense of gratitude. I want to thank President Biden for the incredible honor of this nomination and Attorney General Garland for his strong support. If I am confirmed, I will work every day to demonstrate that I am worthy of their confidence and yours. And I want to thank my family, whose love and support mean everything to me. My husband, Brandon Prelogger, is the best imaginable spouse, friend, and father to our children. Despite having a busy career in humanitarian protection, Brandon has always made time to support me, including being an equal partner at home so that I could pursue my career in public service. We have two wonderful sons, Blaze, who is 10 years old, and Beckett, who's 8. They're both here today. I promised them that we would go out for milkshakes after this to reward good behavior, so actually the whole family has a lot riding on this hearing. My incredible mother, Jeannie Barkis, is here as well. There are no words to express how grateful I am to her for shaping my values and work ethic and always demonstrating the importance of service. I wouldn't be here today without the example she set, the encouragement she provided to always pursue my dreams, and the unending support she's given me to help me reach them. My brother, Eric Barkis, is here also. Pretty much from the day I was born, he's been my best friend. And I finally want to thank all of the additional family and friends who have supported me, including many who I think are probably glued to C-SPAN right now, my mother and father-in-law in Kansas, Mick and Bill Prelogger, my sister Leah, and my nephew Taylor. I wish my father, Rudy Barkis, had lived to see this day. He was an attorney too. He loved the law and took great joy in watching my legal career unfold. I think about my dad every day, and I know how much he would have enjoyed this moment. One other person who's very much on my mind today is Justice Ruth Bader Ginsburg, who I had the privilege to clerk for after law school. Justice Ginsburg was so much to so many, rightly an inspiration for the entire nation. To me, she was a teacher, a mentor, a justice seeker, and the epitome of unrelenting grace. Justice Ginsburg is the person who moved my admission to join the Supreme Court bar, and I have to think that she would have thought there was no better use for that bar admission than to serve in the position for which I've been nominated, as Solicitor General of the United States. When I returned to the Solicitor General's office in January, it felt like coming home. I worked in the office for several years across administrations as a career attorney and more recently as the acting Solicitor General. There is so much that I love about the office, and I can say from that up-close view, there's no better place to work. I love the intense commitment to integrity and professionalism, a recognition that we must turn square corners in our filings with fidelity to the rule of law and the role of the court in our constitutional structure. I love the unparalleled intellectual rigor in our work. We probe our arguments, pressure test our theory of the case, and seek to perfect our presentation in setting forth our understanding of the law. And I love the exhilaration of standing up in the highest court in the nation when it's considering the most important legal issues of our time to present arguments on behalf of a client who I am deeply honored to represent, the United States of America. I am humbled by and filled with joy at this opportunity to lead the office of the Solicitor General. If I am confirmed, I will work as hard as I can every day to honor the traditions of the office, to carry out the responsibilities of this position with integrity, and to serve my country by always seeking to protect and defend the interests of the United States. Thank you for your consideration. I look forward to answering your questions.
Thank you, Ms. Prelogger. And as I introduced you, I certainly am convinced of your qualifications for this and don't feel any less after your opening statement. Dr. Gupta, thank you not just for aspiring to this important position, but for your life's work. As we said in our telephone conversation, I was struck by the fact that you didn't head to the bright lights in your life. You headed to the communities that needed your help, and many times chose rural areas and parts of this country that others might not have chosen in your determination to deal with the drug crisis we currently face and one we have faced over the years. There are two things that I want to make a comment on and ask your reaction to. One, there are many people to blame for the opioid epidemic, and I am not taking away any of the responsibility that they had. But there are two areas that I think have been overlooked. Despite the growing evidence of the addictive nature of opioids, many people in your profession, the medical profession, continued to prescribe these in vast quantities. Some of them were clearly with criminal intent, but others seemed to be with indifference to whether or not the person became addicted to the product, when a conscientious doctor following that patient would have realized it over some period of time. But the drug salesman, whatever other influences were involved in that, pushed many of these doctors to continue to prescribe opioids in indefensible amounts, even after we knew that they were addictive. I'd like your comment on that. And the second one I mentioned to you, it was in this room 6 or 7 years ago where I discovered the role of the Drug Enforcement Agency, which has to approve the annual quota of production for opioid products. They were authorizing at pharma's request, let me underline that, at pharma's request, amounts of those drugs to be produced each year way beyond any of the needs of medical practice. They were clearly setting them up to be part of an illegal, sometimes criminal undertaking in selling these drugs in quantities. Tell me what you think about those two elements and what you're going to do about them.
Thank you, Mr. Chairman. Both are very important questions. I have worked very closely, as you are aware, maybe aware, that West Virginia was amongst the worst hit in terms of shipping of hundreds of millions of opioids into the small state of about less than 2 million people. We've worked very hard across jurisdictions, across the state, as well as in a multidisciplinary and multifaceted manner. I was very happy to see that our reduction in the supply and prescribing of opioids far exceeded many other jurisdictions across the United States, but it takes a lot of effort. There is no doubt that there are doctors who have ill intent in prescribing what I call bad docs. There's also no doubt that there's a lot of other doctors who have been told or otherwise been believed that it's a good idea without having scientific evidence at the time. We still have more other physicians who have just overprescribed. So it's been a problem of volume, it's a problem of diversion, and I think it's going to take us an time to get there, but we must also make sure that as the pendulum swings, we also take care of the people who have legitimate pain. At the same time, the DEA, I agree that that there is a lot of work we still need to do, and if I'm confirmed, you have my commitment to working on both of those aspects.
In our conversation, I also noted the fact that there's been a dramatic change and shift in our feelings about addiction. Sad to say, 15 or 20 years ago, if you said someone overdosed last night, who do you think they are and where do they live? You'd say, I'm going to guess African-American, 30 years old, inner city. And you would have been right. Not so anymore with opioids and heroin and fentanyl and things that are being used now more frequently. Those have affected that white cheerleader girl in the suburbs, and it's her family that comes forward heartbroken and learns that she's overdosed and dead as a result of it. And I think it's forced us to really throw out the stereotypes and look at addiction as a medical problem, not just a failure of moral purpose, but a medical problem. Do you sense that change in conversation as well?
Yes, Mr. Chairman, I hope my being here today as a nominee reflects both the President's focus on this as a public health crisis, which it truly is, which is going to require a lot more than just one aspect. So we have to take all of the tools in our toolbox to act, but it's clearly a public health crisis.
I can't think of a better introduction than to have those two senators from West Virginia and their glowing praise of your work. I'm glad you're taking on this job. And Ms. Prelogar, it's no reflection on you that I directed my questions to Dr. Gupta. I'm for you all the way. Senator Grassley.
Thank you, Mr. Chairman. Congratulations to both of you on your nomination. I'm going to start with Ms. Prelogar. While you were acting Solicitor General, a Bloomberg Law article noted that the Biden administration, quote, is on track to reverse the government's position in more cases before the Supreme Court than the Justice Department did during the first full high court term of Donald Trump's presidency, end of quote. Such flip-flopping impacts the credibility of the Solicitor General. If you plan to continue with this practice, are you worried about the office losing any credibility?
Thank you for that question, Ranking Member Grassley. And let me just say at the outset that I think that consistency and stability are really important values for the Solicitor General's office. I don't think that changes of position should be undertaken lightly. I certainly, in the time when I was the acting Solicitor General, did not make any of those decisions lightly. And I recognize, as your question suggested, that anytime we change position, it's an investment of the office's credibility. The factors that I looked at when I made those decisions focused on two things. First, what are the interests of the United States? And second, what is our best understanding of the law? And we have a very well-established process in the Solicitor General's office of soliciting views far and wide to form judgments about those. Luckily, I did not have to sit there on my own and try to figure it out. We go to every federal agency that has an equity in the subject matter. We solicit recommendations from the litigating components at the department, whether that's civil or civil rights or tax or criminal. And we also go to career officials in the Office of the Solicitor General. There's always an assistant to the Solicitor General and a deputy Solicitor General who weigh in. And I was one of those for many years, one of the assistants in a career spot in the office. So I have a very healthy respect for that process. And only after that kind of extensive deliberation did I make in any of those situations the decision to change position. In the vast majority of cases, we stayed the course with our prior position. But in the limited number of cases where I determined it was necessary, those were the factors that I looked at and the process that I ran.
Okay. My last question to you would be, you were heavily involved in the special counsel's investigation, an investigation that demands transparency and accountability. So I have two questions. Do you know that federal criminal cases are routinely dismissed because law enforcement officials withhold evidence?
Yes, Senator, I believe that refers to the Brady Doctrine as a general matter and the ability or the requirement to turn over evidence, including exculpatory evidence, to the accused in a criminal case.
You were a significant member of the special counsel team. Please explain to me why the cell phone given to you for the duration of the investigation only contained 215 personal photos and why that should not qualify as withholding evidence.
I'm sorry, Senator, are you speaking about the phone that I was given as
Yeah.
part of the special, why it had 250 photos?
Yes.
I did not remember the number of photos sitting here today. I bet most of those were cute shots of my kids. I think probably the answer to that is that I had a personal cell phone at the time, and I tried mostly to use the photos on my special counsel device just for work purposes. But I guess sometimes, I'm surprised there were that many, actually. It must have been the case the kids were doing something cute, so I whipped it out.
Okay. And one question for Dr. Gupta. And thank you for the time you spent in my office yesterday. Your agency is tasked with making and coordinating our nationwide drug control strategy. The agency released a statement of drug policy priorities earlier this year, but a number of important issues were noticeably absent. So at the agency's invitation, I sent a letter outlining what I think should be included in the national drug control strategy. This includes permanently scheduling fentanyl-related substances, dealing with an increased methamphetamine threat, and addressing polydrug trafficking and use. If confirmed, will you commit to reviewing these suggestions and considering their inclusion in the national drug control strategy?
Thank you, Ranking Member Grassley, and thank you for spending the time with me last afternoon as well. If confirmed, I do commit to having in the president's inaugural drug policy these aspects included in a robust manner.
Thank you very much.
Senator Cotton.
Mr. Prelogar, I want to continue down Senator Grassley's line of questioning about position changes of the Solicitor General's office. While you're the acting Solicitor General, I want to speak about a specific case, namely Terry versus the United States, is concerned a crack cocaine sentencing reduction. The United States had been defending this sentence, which is typical in criminal cases, even if it's a close call, even if the government thinks the case may be overturned. But in March, while you were the acting Solicitor General, you waited until the very last moment. In fact, the very day the brief was due, and sent a letter to the court saying that the department had changed its mind following the change of administration. Not only that you wouldn't defend the sentence, but you confessed error, saying the department had been wrong all along. This required the court to reschedule oral arguments. In fact, this is what the court said in its opinion. On the day the government's brief was due, the United States informed the court that after the change in administration, it would no longer defend the judgment. Because of the timeline, the court rescheduled argument, compressed the briefing schedule, and appointed Adam Morterra as amicus curiae to argue in support of the judgment. He has ably discharged his responsibilities. Now, I haven't practiced law in a long time, but that sounds to me like a court that is somewhat displeased the government switched its position at the very last moment in a way that caused them to reschedule their briefings. But here's the thing. Once the government switched its position and the case was argued, it wasn't a close call. It wasn't 5-4 with some anguished majority opinion saying that, well, it's a really close judgment. We understand the dissent's point. The government lost 9-0. And the only reason you lost 9-0 is there aren't 11 Supreme Court justices. The government, in fact, or no, the court said that the government was engaged in sleight of hand. Ms. Prelogar, how did your office get it so wrong? You said that you went through evaluating U.S. interests and what's the best understanding of the law. And just weeks later, the Supreme Court ruled not 5-4, not 6-3, 9-0 that you were wrong in the Terry case. How did your office get it so wrong?
Thank you for that question, Senator Cotton, and I appreciate having the chance to talk about that case. I certainly found that to be a very difficult decision in making the decision that we should ultimately confess error in that case, which is a longstanding tradition within the Solicitor General's office when we determine that that's appropriate in the interests of justice. I did focus on the legal issues involved and ultimately the interests of the United States. The question in that case is whether the lowest level crack cocaine offenders could be eligible for resentencing under the First Step Act. It was a given that the individuals who were responsible for greater quantities of crack cocaine fell within the provision. And so the only question was whether those lowest level offenders also could get that kind of sentencing relief, the possibility of it under the First Step Act. That was a question that had divided the circuit courts. Circuit judges appointed by both political parties had disagreed on that issue. And ultimately, after looking at all the tools of statutory construction, the text of the provision, the context, the purpose, it was my judgment that Congress had intended to extend that sentencing relief to the low-level offenders. The court...
I'm sorry, our time is limited here, but I mean, do you think having switched the government's position and then being rejected 9-0 just a few weeks later by the Supreme Court, I mean, do you think you got that decision wrong?
Well, Senator, I certainly respect the Supreme Court's decision and the fact that the justices disagreed with our position in the case. Ultimately, I wish that we could persuade the court of our position in each and every case, and I can't quite bat 1,000 like that. But ultimately, as Justice Sotomayor observed in her concurring decision in the case, the ball is now in Congress's court if it wants to extend that kind of sentencing relief to the low-level offenders.
After having joined the majority 9-0 opinion that said it was not a close call at all, that letter was submitted on March 15th. Are you the one who personally made the decision to confess error in the Terry case?
I am, Senator. I was the acting Solicitor General at that time, so I was responsible for all of our litigating positions on merits cases in the Supreme Court.
Did any higher-ranking official in the Department of Justice direct you to make that switch?
No, Senator.
Did you consult with any higher-ranking official in the Department of Justice?
Well, I don't think it would be appropriate for me to discuss internal deliberations at the Department of Justice. I can tell you as a general matter that the Solicitor General's offices solicits viewpoints and perspectives from all interested components. That can include the leadership offices. It can include the federal agencies and, of course, the litigating components as well.
And you'd said in your response to Senator Grassley that one of the things you do is go to litigating components and agency with equities. The acting Attorney General for the Office of Legal Counsel, when he testified in front of this committee a few months ago, said he was not consulted in this case. would it be the Solicitor General's normal practice to go to the Office of Legal Counsel on a question like this when you're thinking about switching the legal position?
So as a general matter, no. When a matter is in active litigation, the litigating components handle that rather than the Office of Legal Counsel.
All right, well, my time's expired. As Senator Grassley said, this is part of a pattern. This is just the most egregious case since the government switched from its previous position and then lost 9-0 at the Supreme Court. I can keep going if the chairman wants me to.
Pardon me.
I can keep going if he doesn't have anyone else to ask questions.
We certainly enjoy your questions. Thank you, Senator. Senator Cruz has said he is returning, but do we have any indication where he is? Now, Senator Cotton, you see my dilemma. The witnesses are here and the senator is not, and I want to accommodate him if I can.
It was going to go.
I'm sorry.
Oh, just Senator Klobuchar, just trying to ask questions.
Well, there we go. Senator Klobuchar virtuously and virtually.
Well, I will try to be very quick, given that I know we're trying to wind up. I wanted to thank all of our nominees. And Dr. Gupta, we talked yesterday. Your nomination is supported by both Senator Manchin and Capito, as well as West Virginia's Republican governor, who said this: "I believe that there is no one better suited to this important job than someone who represented a state and a people where the opioid crisis really hits close to home." In your view, how is this support from across the political spectrum going to help you in this job?
Thank you, Senator Klobuchar. It was indeed a pleasure to speak with you. I believe that it's important when we're dealing with the epidemic that has claimed 95,000 lives predicted as of January for 12 months period, January of this year, that we work in a manner that helps to address the public health crisis that is. It's a complex and difficult situation, and Americans need our help. So it's going to involve entire village to help, to be honest. And I think it's going to be important whether we're looking at supply side issues or demand side issues. We're going to need to have a lot more effort moving forward. The president's budget proposes significant and historic funding levels to support that work. And I believe that the support that has been demonstrated of my record reflects my ability to work across lines and across communities and stakeholders.
Well, then one last question here. In a 2018 editorial of the Marshall Journal of Medicine, you discussed how over-incarceration, addiction-related issues complicated some of the issues about responding to the epidemic. I've been a longtime supporter of drug courts from my time as a prosecutor. I grew up as the daughter of an alcoholic and well aware of how treatment can literally change someone's life. And just briefly, if you could address drug courts and how you will champion them, I hope, on both the state and federal level in this job.
Thank you, Senator. I have worked very closely with the state drug courts and systems. There is clear evidence to demonstrate that the 4,000 treatment courts across our nation that are looking at about 150,000 Americans to help have demonstrated clear benefit. That includes both reducing crime, but also saving almost $6,000 a person. It also has a disproportionate impact benefit in employment, schooling, and other societal and community impacts. So I hope that we can continue to advance that part of the solution for this crisis, for this particular epidemic.
Thank you. And I will not put my questions for you, Ms. Prelogger, on the record, but congratulations on receiving letters of support from several former Solicitor Generals, including every Solicitor General who served in Republican administration over the last 3 decades. That is very impressive. With that, thank you very much, Chairman.
Thank you, Senator Klobuchar. The letters on support of all 4 of the witnesses this morning will be placed in the record without objection. And questions for the record are due to the nominees by 5 p.m. on Tuesday, September 21st. The record will remain open until that time to submit letters and similar materials. Thank you to the witnesses for your patience today. And with that, the hearing stands adjourned.